item number 61, bail hearing. I seek permission from Mr. Kyle also.
Yes.
Can it be taken up at 2 p.m.?
Okay, we'll take. There's one matter fixed at 2. Immediately after that, we'll take it.
May it please your lordship. Lordship, I beg to mention item number 15, my lord. It
16?
arises
One
1-5, my lord. 15.
Oh, 15.
I am for respondent number 3 and 4, my lord.
Mhm.
My learned friend is for the petitioners, my lord.
Mhm.
It's an NIAC matter and
Mhm.
talks of my lord compromise as far as instructions are going on.
Mhm.
So matter may be listed after the vacation, my lord, as per the registry. My lord.
Okay. It is submitted, DK Boydell, learned counsel for respondent number 3 and 4.
Four, my lord.
You are for the petitioner.
Lordship.
Full stop. Along with the learned counsel for the petitioner, submits that efforts at settlement are going on in a positive direction and prays for listing the matter after the vacation. Prayer aloud, list the matter in January on a date to be fixed by the registry.
Hello, Bless.
May I please, Your Lord? With all respect, Your Lordship, that for the last 2 days, my matter has not been.
Yes, which matter was there? Your
Item number 59, Your Lord.
59.
Yes, Lord.
Yes,
It-
you had mentioned yesterday. also.
Yes, yes. Can it be on at 2, Your Lord?
Bail hearing, I think it will go fast today and I think it should reach in the normal course. In case it does not, we'll adjust. Yes, I will adjust, don't worry. Bail at least I'll finish. We'll go fast today. Concise
Well-
commissions, concise orders. Yes.
May I listen? I beg to mention item number 50, 51 and 52.
Fif-
It is a
fif-
hearing matter.
50,
51, 52. It is a connected matter.
51, 52.
Hearing matter.
Hearing, 50 is also there.
50, 51, 52.
52. Yes. What is the another day?
After vacation.
Any case, it may not reach. This prayer of the learned counsel to the petitioner. The matters may be posted after the winter break on a date to be fixed by the registry, right? Okay.
Well, there is a state of this.
The interim order granted by order dated so and so stands extended till the next date of listing.
I beg to mention, listing the matter, I file a IO for
Okay.
IO for correction of address the petition.
When do you want it?
21.
No, when do you want it? Which date?
Monday.
Okay.
May I please, Lord Sabha? I beg to mention item number 42. Although that was mentioned on Tuesday to withdraw the case, but it has been listed today itself.
Again.
Again, Lordship.
Okay.
So it may be withdrawn.
Withdrawn. A.K. Sharma, learned counsel, 6 to withdraw this matter on instruction. The matter, allowing the prayer, comma, the matter is disposed of upon withdrawal.
Replayable.
42, no?
42.
Your Honor. Your Honor, I'm praying for listing of 2 criminal petition, Your Honor, for admission on 9th of December.
Right? Oh.
Please, your lordship, I'm praying for listing criminal petition on Monday,
Bill Monday.
criminal petition.
Lordship, paying for listing for AB lordship.
When?
Monday lordship.
How about Wednesday? Because Monday we have fixed many matters. AB, it's okay, Monday.
May I please, Your Lordship? Your Lordship, I beg to mention 1 AB for listing in motion column, Lordship, on Monday, Lordship. And similar prayer for 1 criminal petition.
Criminal
for-
petition, let it be on Wednesday, right? Okay. AB on Monday. Huh?
May I please, Lordship? Regular paying for listing on Monday, madam.
Regular bail petition. List it on Wednesday, if you don't mind. Wednesday.
May it please, your lordship, I beg to mention item number 49. Lord Devastan. Notice has been served upon respondent number 2, my lord, and one appeared, my lord, may it be taken up after a week, my lord.
49, there are 2 respondents.
This has been served.
Okay, no, state.
Private,
Private respondent served.
served.
Learned your good name, please.
K.A. Sodhyal.
K.
K.A. Sodhyal.
Okay. Learned counsel submits that notice upon the private respondent has been served. Stop.
That's the interim, my lord.
And prays for listing the matter after vacation. The interim order by order dated so and so stands extended till the next date of listing. List the matter in January on a date to be fixed by the registry. Objection.
May it please, also I beg to mention item number 45.
Yes.
Adjourn for the day.
Not
Today is not available.
not today. 45. There is not available. Issue fresh requisition. Interim is there. No. List the matter next week. No? next, let it be on, Wednesday, next, third, Fourth.
Next Friday, my lord.
next Friday.
Yes, because CD has to come, my lord.
Okay.
Eh,
Five,
Subject to your.
5:12, 5:12.
Subject to
Okay,
your
no, it's
lordship.
okay. Okay, no problem. AB 45. Yes.
May it please the lordship. Lordship, I beg to mention item number 2, lordship. Lordship, kindly pass over for the day, lordship. And can it be on 3rd December, lordship?
Neat. Okay. Adjourn the matter for the day and fix on 3:12.
Lordship, I have a similar prayer for item number 41, lordship.
41.
41, lordship.
41 CD received, man.
Okay. This one we fixed on 3rd. Right.
Prayer, lordship.
CD be retained. CD is received and shall be retained. List the matter on 3:12. Obliged.
May I please, lordship? Lordship, I beg to mention item number 54 for withdrawal, lordship.
54 for withdrawal. Learned counsel seeks to withdraw this matter. Admission, right? Admission, criminal petition. Your good name, please.
M. Rahman. on
M.
behalf of
Rahman.
N. Ahmed.
And on behalf of N. Ahmed, seeks to withdraw this petition upon instruction. Allowing their prayer, the petition is disposed of on withdrawal. 54.
Lordship, for listing on criminal representation.
Criminal revision. Let it be on Thursday or next week. Thursday, 4.
May I please your lordship? I beg to mention criminal revision petition 87/2025
Mhm.
for listing on 5/12/2025. This is regarding interim maintenance has been stopped. So
5:12.
5/12.
Okay.
Oblige your lordship.
May I please, your lordship? Lordship, I beg to mention item number 30, lordship. In this case, lordship, the scan copy of charge sheet and the case diary was called for, lordship. Now, lordship, that has been not been received, lordship, and now the lordship NDPS case has been registered.
Hmm.
So scan copy of the trial court record in connection with.
Charge sheet has been submitted.
Yes, sir.
Already. It is submitted that Mr. Thakur submits that in the meantime, charge sheet has been submitted and perhaps scan record can be called. Stop. Call for the scan TCR comprising case diary, charge sheet, FSL and other relevant documents.
Lordship, in connection with lordship NDPS case number 435 of 2025, lordship.
From the court of
From the Court of Additional District and Sessions Judge Nong 1, Kamrup Metro, lordship.
Kamrup number 1.
Number 1.
Oh. Date 2, this list after 10 days on a date. Some dates we should leave to the registry also. I think it's better. There will be more harm.
This after 1 week, lordship.
Okay, that will be helpful. Okay. I'll give you a date just a minute. 8/12.
Lordship.
1 week.
Obliged.
Not on B item number 1.
Case diary.
Yes, Lordship.
Call for the diary.
Lordship, date may be fixed, Lordship.
Hmm?
Date may be fixed.
Okay, I'll fix it. This is case diary or
Case diary.
Or case record.
CDML.
case sheet? It's charge sheeted case.
No.
Investigation case. Call for the case diary of Karimganj PS case number 290 of 2025. The accused was arrested on 17/6/2025. The case is stated to be at the stage of investigation. List the matter on
Your Lordship, make it 10, Your Lordship. 10 or 11. 11, 12. 11. Must apply.
Item number 3.
There's no bill application, madam.
Yes.
Wildlife protection, madam.
wildlife
So, cartoon is there.
Madam, I will have to inform special PP, madam.
special PPS. And inform, you must have soft copy, right?
Madam, he can appear, madam, with police station case,
no.
madam. Jofla Mano is.
No, the special PP Assam.
Issue with us.
Chokla Manda.
He can appear, madam, police station, madam.
It is a regular, he was arrested, right?
Yes, 9/12, my lord.
Achha.
On the basis of the statement of the co-accused, my lord, he was apprehended, my lord. FIR is at 9 case level.
Okay, let us get the case diary. You must have served copy to the special PB, right?
Yes, I have
You must.
already had.
Call for the case diary of Jakla Banda, PS case number 106 of 25 under so and so. Stop. Copy has already been, copy is stated to have been furnished to the learned special PP, Wildlife Crimes, Forest Department. Achha, you are right. Mr. D. Bhatak. I bought. Ishan bought. I bought a learned counsel as appearing for the Forest Department, Wildlife Crimes. Stop. He was arrested on, the petitioner was arrested on 9/11/2025. List the matter on, can you suggest a date? Because he is in custody.
From Nagaon, my lord. Can it be on 10th or 11th, my lord?
Yes, I was thinking of giving before that only.
Okay.
On 14th of December, my lord.
14th, 14 is holiday. 11th, 10th.
Matter number 4. May I please your lordship. Here this case, lordship, petitioner was arrested on lordship 15/10/2025, as on date lordship 44 days.
Mhm.
What had happened, lordship, in this case, lordship may kindly come to the FIR first, lordship, that is at page number 15, very small FIR. He was arrested, he was released on bail on the same day.
Mm.
Subsequently, lordship, on the very first day, NBWA was issued, and lordship, on the strength of NBWA, he was arrested.
Very first day. How
Very
come?
first date, lordship, and lordship, section involved is 9 and 10 of the Prohibition of Child Marriage Act. Page number
Under
15.
prohibition.
I am not the prime accused.
Submission is certain. You can read that, right?
Yes. Humble submission is that I am the informant on 25/2024 at around so and so. Got information over telephone that minor daughter of namely so and so, one Asabuddin, a resident of so and so, was given marriage with one Bilaluddin, son of so and so, so and so. With regard to the said offense, the Pathagandhi police have conducted investigation, and after recovering the victim, apprehended some persons who are involved in the said offense. The police have seized the birth certificate of the victim. It is revealed from the birth certificate that the victim has not attained the age of 18 years. Here, lordship, the petitioner is neither the bridegroom or lordship, he was not a relative of those persons. My lord, may kindly come to page number 32 for a moment. 31. This is the charge sheet. 31. At the top,
Already charge sheeted also.
already charge sheeted.
Achha.
At the top, page number 31,
Yes.
Ali Hussain.
Huh.
Now, my lord, may kindly come to Roman 16. Date of arrest 21/5/2024. He was produced on the same date. He was released on bail. 21/5/2024.
Released on bail, which column it would be? Date of release is blank. Date of release is some-
Forwarded on same date. Subsequently, he was released.
released on bail.
He was released on bail.
And then
Now, lordship may kindly come to page number 38.
cases at the stage of trial.
Yes, sir. Page number 38, madam. For a moment.
Just a minute, huh?
Order dated 29.
Just a minute, I'm just seeing this order once, 29/11.
29/11, lordship.
Okay, now 39.
38, my lord. First
Hmm.
order, 29/11/2024. CR received on transfer. That was the first date. All 7 accused persons, excluding this petitioner, Ali Hussain, is absent with step, fight petition number so and so, which is allowed.
Hmm.
Issue NBW.
No, that's maybe.
On the very first day,
How can you do that? No.
very first day NBW was issued, and lordship, on the next date, lordship, he was produced before the court on the strength of, he was arrested on the strength of arrest warrant, lordship, page number 40. Page number 40, order dated 15/10/2025. Accused Ali Hussain is produced physically before me following his arrest, same so and so, so and so. I am ready to face the trial, lordship. I am not the prime accused, already 44 days. I will not be default any further, lordship. With any condition, lordship may kindly allow my prayer.
Yes,
Yes, my lord, since 29/11/2024, my lord, he has not appeared. For which, my lord?
29, no,
Yes,
but on that day he was absent with steps.
No, my lord.
No, I was not.
Oh, absent with steps by all 7 accused except Ali Hussain. Ali Hussain.
Oh,
has
achha,
not
without
appeared.
steps.
Yes, sir.
Without steps. So from.
But still,
29
first
Yes.
summons, then BW, then NBW.
Yes, sir.
That should be followed. Anyway. Should we call for the or dispose it of?
Your lordship may dispose of the.
Okay. M. Ahmed, Learned Counsel for the petition and additional, the invoking section 483 BNSS, the petitioner Ali Hussain is seeking a bail with regard to special PCM case number 9 of 2025 arising out of Patharkandi PS case number 156 of 2024. Let's stop. Under section 9, 10, 11 of the Child Marriage Act. He was arrested on 15/10/2025 on the strength of NBWA issued by the learned court below. The case arose out of an FIR dated 21/5/2024 alleging child marriage in which 3 persons were named. 3 persons were named, which does not include the present petitioner. However, he was sent up for trial in the charge. By the order dated 29/11/24, it is stated by the learned court below that all the 7 accused persons were present, were absent with steps except the petitioner Ali Hussain, whereupon NBWA was issued. It is stated and submitted that he has already spent 44 days in custody, and also submitted that he will appear regularly and there is a trial. The certified copies of the relevant documents have been annexed, which I have perused. Allowing this bail petition, it is directed that the accused so and so is hereby allowed to go on bail of rupees 25,000 with 1 surety of the like amount to the satisfaction of the concerned learned court. Additional session just,
Yes,
right?
my lord. Additional
For
session,
input.
sir. Shribhumi Hasan.
Satisfaction and subject to the condition that he will be available during the trial and not hamper or activities. Bail petition stands allowed and disposed of. Therefore, so it does. Yes.
Highly applies.
Article 5.
Please, Your Lordship. My lord, in this case, my lord, the offence is under section 21A, 27A of NDPS Act. But at this stage, my lord, CD may be called. 484, 111.
Yes. Call for the case diary. It's under investigation, right? Investigation probably. Call for the case diary of Lonka PS case number 233 of 2025. And that's when the accused was arrested on 1/11/25. This is the matter on, you can suggest a date.
17/12.
17/12.
11.
Item number 6.
Yes, sir.
Call for the criminal lordship. It is 22C lordship.
No hands. Call for the Nagaon PS case number 818/25. He was arrested on 16/10. Shall we have the same date?
5th of January, as per his.
Oh, that'll be quite long, I think, isn't it?
22C is there.
That's true.
Actually, lordship, what happened in this
All
case?
18 December, 18/12.
A small submission, short submission. What happened in this case, lordship? This particular petitioner is himself a drug addict person. I have an expert document also at page
So
13.
that's okay. You should rehabilitate and cure himself, isn't it? He should rehabilitate himself, cure himself. And on my part, regular bail application, I should not fix it after 40 days, right? It will not be proper. 17/10.
Offline.
Item number 7.
May I please, your Lordship? Lordship, the petitioner is booked under section 22C of the NDPS Act. And in the instant case, Lordship, actually, the alleged recovery was made from a tempo vehicle. And wherein the petitioners are not the occupants of the vehicle, nor they are the owner of the said vehicle. They were traveling on a swift vehicle from which no recovery was made.
I see.
However, they have been connected with
Raided with the, as an accused.
with this. Otherwise, the main ground for my bail, pressing this bail application is that the recent judgment of the Honorable Supreme Court, your Lordship may be well aware of that Mihir Rajesh Shah, which says about the 2 hours rule prior to the production, that has not been complied with.
It is at the stage of investigation.
Yes,
Right?
yes.
Let us call for the case diary and we work out the date. What are which? Okay, call for the heard, Ms. Banik, right?
Yes.
L. Banik. Ms. L. Banik, learned counsel for the petitioner. Kotakut. Call for the case diary of Hajo PS case number 363 of 25. In the section so and so. The accused was arrested. The accused persons were arrested on 25/8/2025. It's stopped. It is submitted that the land council submits that there was no recovery from their vehicle, and that the contraband was allegedly recovered from one tempo vehicle. Tempo vehicle. And that the present petitioners were traveling in a swift vehicle. Swift. Yes. List the matter on.
He is traveling in the same vehicle. Madam.
Anyway, we'll not write that. You may get it wrong. Factually, we'll not write that. At the time of disposal, we'll discuss that. He was arrested on 25/8/2025. List the matter on 18.
Supplementary 53.
This case is under POCSO, madam.
Okay. First time it's come. Right?
Yes, madam.
Issue the notice.
Right.
The call for the case diary of Karimganj PS 440.
From his vehicle, some cows were recovered. What happened, these cows were bought by some customers, and I was assigned to transport the cows to their respective homes. The sale, you will find the FIR at page 8.
Yes.
And the sale agreements, sale letters are also next, my lord.
Shall we read the FIR or just call for the case diary at this stage?
At this stage, I'm
You're
What happened, Malad,
seeking
if-
some relief, then let us read the FIR.
my lord. With due respect, I beg to state that on 10/10/2025 at about 7 AM, one C Ojit Gogoi of BDP under Sonari Police Station called and informed to officer in charge of Tingalibam Police Outpost that the villagers of the Oguri Pathar kept hold of a stolen Bolero vehicle. Stolen cattle Bolero vehicle, white vehicle number. May I read the Assamese version, my lord?
That's always the original.
My friend will help me in the reading.
Yeah, no problem.
মহোদয় সন্মানপূৰ্বক নিবেদন এই যে যোৱা ইংৰাজী 10/10/2025 তাৰিখে ৰাতিপুৱা 7 বজাত টিংগাৰীবাম আৰক্ষী চকীৰ ভাৰপ্ৰাপ্ত বিষয়া মহোদয়লৈ সোণাৰী থানাৰ অন্তৰ্গত লুকুৰাখোন গাঁৱৰ VDP শ্ৰী অজিত গগৈয়ে ফোন কৰি জনায় যে সোণাৰী থানাৰ অন্তৰ্গত ঔগুৰি পথাৰ গাঁৱৰ মানুহে এখন গৰু চুৰি কৰি অনা বলেৰো গাড়ী ধৰি ৰাখিছে। গাড়ীৰ নম্বৰ গাড়ীৰ পিছফালে বডিত 11টা গৰু পুৱা লোড হৈ থাকে আছে। গাড়ী চালকজন পলায়ন কৰে বুলি জনোৱাত টিঙালিবাম আৰক্ষী চকীৰ ভাৰপ্ৰাপ্ত বিষয়া মহোদয়ৰ লগত ঔগুৰি পথাৰ গাঁৱলৈ গৈছিলো। গাঁৱলৈ গৈ দেখা পালো so নম্বৰৰ এখন বলেৰো গাড়ী পথৰ কাষত আছে। গাড়ীৰ পিছফালে বডিত বিভিন্ন ৰঙৰ 4টা গৰু লোড হৈ আছে। গাড়ীত কোনো মানুহ নাই। গাড়ীৰ ওচৰতে পথৰ কাষত থকা খালী ঠাইত বিভিন্ন ৰঙৰ বলদ গৰু, গাই গৰু, দমৰা পোৱালি 7টা দেখা পালো।
উক্ত স্থানত থকা মানুহক সোধ-পোছ কৰি জানিব পাৰো যে পথৰ কাষত থকা গৰু 7টাও উক্ত গাড়ীখনতে আনিছিল। গাড়ীখন বেঙেনাবাৰী দিশৰ পৰা কানুবাৰী দিশে আহিছিল। গাড়ী চালকজনে পথৰ কাষত খালী ঠাইত হঠাৎ গাড়ীখন ঘূৰাই দিয়াত স্থানীয় মানুহৰ গাড়ীখনৰ ওপৰত সন্দেহ হোৱাত গাড়ীখনৰ ওচৰলৈ মানুহ যোৱাত চালকে গাড়ীৰ ভিতৰৰ পৰা এখন মিৰ্দা উলিয়াইছিল। তাৰ পিছত মিৰ্দাখন গাড়ীৰ ভিতৰত ৰাখি পলায়ন কৰে। গাঁৱৰ মানুহে পিছফালৰ বডিত 11টা গৰু লোড হৈ থকা দেখা পালে, ভিন্ন ৰঙৰ। তাৰে কেইবাটাও গৰু মৰাৰ দৰে দেখা পায়। গাড়ীৰ পৰা বলদ গৰু, গাই গৰু, দমৰা গৰু, ভিন্ন ৰঙৰ 7টা গৰু নমাইছিল। গাড়ীৰ পৰা নমাই নিনিয়া হলে মৰি থাকিলেহেঁতেন। স্থানীয় ৰাইজে চালকজনক ধৰিব বিচাৰিছিল যদিও পলায়ন কৰে। চালকৰ নাম শ্ৰী উজ্জ্বল বৰগোহাঁই এলিয়াছ অম্লান বৰগোহাঁই, ৰেচিডেন্ট অফ সোইনচ বুলি স্থানীয় মানুহৰ পৰা জানিব পাৰো। চালকে গৰুসমূহ চুৰি কৰি আনিছিল, সেইবাবে পলায়ন কৰে। সেয়েহে মুহূৰ্তৰ পিছত গাড়ীখনৰ
He was literally arrested.
No, my lord, he has not been arrested, my lord. These cows
Was
were
the LD.
bought by, my lord, some other persons. Also, will find the sell deeds, my lord. I will read the vernacular portion, my lord. Case 16, my lord. আজি 10-10-2025 তারিখে মোর অবস্থা কি অসুবিধাৰ টকাৰ আৱশ্যক হোৱাত মোৰ ঘৰৰে পালন কৰা 3জনী গাই গৰু নগদ ইমান টকাত উপৰোক্ত বৰাবৰক বিক্ৰী কৰো, চুক্তি বিক্ৰী কৰো। প্ৰকাশ্য যে উপৰোক্ত বরাবরে গরু কেইজনী পালন করার উদ্দেশ্য করি, অন্যথা এই ঘর পান নাকচ হতে। This is all, my lord. This is what-
Rinal Gogoi is the owner of the,
Yes,
he bought the cows and he
He
was the
bought-
driver.
yes, my
He
lord.
was the driver.
And,
In a Bolero vehicle, my lord, those cattle.
My lord, my
My cruelty.
my contention is that, my lord, if the owners of the cows are, my lord, are not asked, the actual fact will not be revealed. And my statement may be recorded in.
He was the driver.
I was the driver, my lord. I am.
Mr. Saikia, huh? That's it, Land Council and additional people. 482 bail application seeking pre-arrest bail for Krishna Onlanjuti Borgohain in connection with Sonari PSK 99 of 25 under section so and so. FIR is dated 12/10/25, in which allegations were about carrying 7 numbers of cattle. 11 numbers of cattle suspected to be stolen in a vehicle, in a Bolero pickup vehicle bearing number AS3361051. The petitioner is stated to be the driver of the vehicle who allegedly absconded from there on the place. The learned counsel has drawn my attention to cattle sale agreement whereby some cattle were purchased by Mrinal.
Three different persons, my lord.
Three different persons from the seller Forest Rajkornam. The petitioner is stated to be the driver of the vehicle carrying those cattle and stated to be legally purchased. Call for the case, call for the case diary from the concerned police station. However, in the interim, 25,000 with 1 cooperate, appear before the Ayo, not hamper or temporary evidence. Okay,
Deep level.
this is the matter. Long delay. 7-1. 7-1.
Item number 9. Item number 9.
Sometime.
Item number 10.
My lord, kindly take it up after some time, my lord.
After some time.
TV is on live.
May I please your lordship? This is a offense report case, lordship. And forwarding report is the FIR here. Page number 11. Special PP for special PP for us.
Bhattacharya is the parent.
Yes,
Vishal Bhattacharya. He will appear.
After some time. Lordship, in the he may come, may I submit, lordship? Actually, what happened, lordship, he is a person, the petitioner is a person who is seeking anticipatory bail. Usually he use this use firewood for cooking meal. And lordship, somebody cut it 18 numbers of trees, and thereafter, lordship, some persons are arrested. And while the forwarding report is submitted before the trial court, lower court below, then our name is there, lordship, in paragraph number 4, page number 12. That, madam, above the 3 aforesaid arrested accused persons, one suspected accused, so-and-so, Narjari, son of so-and-so, address so-and-so of Dhemaji, Assam, has been absconded. And lordship, I want to appear, lordship,
Let him come. It's better to hear. Once he comes, we'll hear
Yes, sir.
and then pass orders. Motion.
Motion item 12.
Yeah, please, your lordship. This case, my lord, had arisen out of a check bounce issue, my lord.
Yeah.
My lord, the petitioner, my lord, before your lordship, for my lord, recalling of the impugno arrest warrant, my lord, and proclamation has been issued. If your lordship kindly peruse the type copy at page 27, my lord. No warrant, no summon was received by me, neither the notice was received by me, my lord.
The case is at the stage of trial.
Appearance, my
Then
lord. Appearance.
appearance and
Yes.
warrant was
Yes,
issued.
my lord. And lordship, if your lordship kindly see the copies of the my lord, warrant which
Just a
was
minute.
issued against me
Transfer.
on at page 41.
It's just a minute. Absolute steps. (11:10) the case is received, right?
Yes, my lord.
For 27:12. The complaint. Government submission grants and governments. Summons.
Hereafter, my lord, 7/4.
There's no mention about whether summons was
Yes, my lord.
served, returned back.
My lord, that I
DW was issued.
Yes,
Anyway,
that your lordship will find
and then you wanted me to see page 41.
page my lord, 41, my lord. This is the warrant of arrest, my lord, issued. It has been returned, showing the reason at page 41. With due respect, this is to inform you that the arrest of the warrant in respect of the accused person so and so, my lord, could not be found. Therefore, this is to inform your honor. But this was returned, my lord. It was never received by me. And why should I ignore that code, my lord?
This was a NBW.
NBW, my lord. Hereafter, if a lordship kindly turn on next warrant, my lord, at page 44. This was also written, my lord. With reference to the non-billable warrant of arrest against so and so could not be found to the address given to the warrant, my lord. So, lordship may protect I will appear, my lord. The next date of the case is on the 2012.
2012.
My lord, 2012, 25. And amount is also, my lord, disputed, my lord. If your lordship see the check amount at page 19, that is, my lord, amount is 67,000 rupees.
67.
7,000. And lordship kindly peruse the next page, page 20. Page 20 is my notice, my lord. I issued a notice to the complainant, informing him. Then, since I have made a payment of lordship para 2, my lord.
Page 27.
27. Page 20.
Yes.
I have issued this notice, my lord, informing the complainant. Then, since the payment has been made an amount of rupees 40,000. So you are requested to return the original check and take a new check of amounting to rupees 27,000. After receiving
This 40,000 has been paid.
my lord. After that, my lord, he have lost this problem case, my lord.
Okay, and the check amount has been mentioned as 67,000.
Yes, madam.
Now, if that is true, then as per the settle law, whatever I know, is that it has to be filed for the only 27.
Yes, my lord. That's why I issued the notice. Instead of taking the check, my lord, he have filed a complaint case against me, my lord.
Yeah, state is the other parties. We have to issue notice at this stage.
No, see, dispose it, my lord.
But yeah, I was thinking, but some interim order I think has to be given. But shall we
But-
dispose of, or because the other party is
the
not there?
direction. Well, if you are, my
That's
lord.
true, but that's true. But the other party,
Because
otherwise it will take time.
Yes, my lord.
yeah, and also direction will be made to provide him the correct address before the
Well,
trial. Because of that.
yeah.
That's true.
My lord, my character, my address is written here, my lord, in the petition, my lord.
The third also and the invoking the powers in the 428 528 BNSS, the petitioner Amarjyoti Chaudhary is seeking interference and quashing of order dated 23/4/2025 passed by the learned JMFC Kamrup Metro Guwahati, issuing BW proclamation is there.
Yes, my proclamation is there, my lord.
Where?
My lord, lordship में not original one, my lord.
The
Original
proclamation is issued, anticipatory bail cannot be filed, but you are filing a criminal petition.
Yes, my lord.
It's okay. Issuing NBW and proclamation against the petitioner in CR case number 3999C with the superscript 3 of 19. The whole case actually, that is what
Page 37.
Hmm.
Proclamation, my lord.
page.
37. That is the, my lord, order, my lord, impugn order. Page 37, my last paragraph. Issue proclamation against the accused. Last third line, my lord.
The impugn order, it is stated that NBWA upon the accused petitioner was returned with the report that he was not found at the given address. They submitted on behalf of the petitioner that the check on the proceeding under section 138 of the NI Act was initiated with regard to a check check amount of rupees 67,000, and that even with regard to that, the petitioner has already paid rupees 40,000. And in this regard, he has also issued a notice to the complainant side, which is annexed as Annexer 3. They submitted on behalf of the petitioner that he will appear and he is willing to cooperate with the further proceedings for the learned court below. I have perused the relevant copies of the orders and other documents annexed to the petition, and I deem it possible to dispose of the matter at this stage only. Accordingly, the NBWA and proclamation issued against the petitioner, accused petitioner by order dated 23/4, right?
Yes.
25 in CR it will hit you. Is set aside and quashed. And the petitioner is directed to appear before the learned trial court on the next day, which is fixed on
2012, my lord. 2012.
2012, and on the subsequent dates as per law. He shall also provide his correct and present address before the, he'll also provide the correct and proper address before the learned trial court. Okay. The instant criminal petition stands allowed and disposed of on the aforesaid grounds. Anything else? These things did not detain us.
But
What killing this? Disposed of.
Item number 11, time being.
Sir, what?
till now, he's not there, my.
It doesn't. Next, 13.
13. Wait, please. The petitioner number 1 is the wife of the respondent number 2, lordship, who is the husband, lordship. The husband lodged an FIR against the petitioner number 1 and her family members, including her father, lordship. Thereafter, charge sheet was filed against the petitioner number 1 and her family members under section 420, 406, 34 of IPC, lordship. Thereafter, the learned trial court, without going to the facts and materials of the case, passed in the cognizance order under section 420, 406, and 34 of IPC against the petitioner number 1 and her family members, lordship. It is purely a matrimonial dispute, and lordship, it is settled law that 420, 406 of IPC cannot run simultaneously.
What is the allegation? This is the FIR.
FIR is at page 17, lordship.
Okay, I am on 17 only.
Page 17, lordship. The husband lost the FIR, lordship. Respondent number 2.
Okay.
So I am the petitioner number 1 is Taposi Soikia, that is the wife, lordship. And Kukeswar Soikia is the father of the petitioner number 1. And Ranimai Soikia is the auntie of the petitioner number 1, lordship. Thereafter, charge sheet has been filed, lordship.
Misrepresentation, basically.
Lordship.
Right? How is it criminal breach of trust?
Lordship, how it came, lordship.
Anyway, I don't know. There may be something which
Lordship.
we don't know.
Lordship.
Superficially, we are looking at.
Lordship.
So at this stage, you issue notice.
Lordship, and this proceeding may be stayed, lordship. That much, lordship, because the father is 61 years of age, lordship. Impugn order is at page, lordship, 33, lordship.
You are seeking quashing on the ground. Now I will not,
Lordship, let the.
waste time on this, but you are seeking quashing on the entire proceedings.
Lordship, charge sheet as well as the proceeding, lordship.
On the ground that, main ground is that, what is the main ground?
Lordship,
Just
basically
asking.
420, 406 ingredients are not there, lordship.
Okay,
In the
that
FIR
can,
itself,
that can be, ground. Otherwise, as far as coexistence of the two things are concerned, of course, it cannot be both, because
Lord-
also race club, because
Rest,
one is, in one, the transfer of property is illegal,
lordship,
illegally taken,
Lordship.
cheating. And the other one, it is legal transfer, which subsequently becomes illegal.
illegal, lordship.
So that is why, but whatever I've read is that the court can frame alternative charge also,
Lordship.
but not joint charge,
Lordship.
alternative charge. Anyway, that we'll see, because the ingredients have to be seen, because that will not be sufficient, may not be sufficient ground for caution,
Lordship.
but otherwise ingredients we can see whether it is sufficient
Lordship.
individually.
Lordship.
Heard,
Keyboard letter.
I know, 528 VNSS, seeking quashing of order dated, you're seeking the entire quashing of entire proceedings, right?
Lordship, order dated.
Order dated
As well as a charge sheet, lordship.
19/10/2025 passed by learned JMFC Tezpur in PRC 843 of 25, taking cognizance against the petitioners, taking cognizance under section 420, 406, 34 IPC. The petitioner is also seeking quashing of the charge sheet number 506 of 25 in the said case arising out of Tezpur PS case number 467 of 25. Full stop. The petitioners herein are stated to be the wife,
Father-in-law,
father-in-law and mother-in-law, and
aunt-in-law, lordship.
aunt-in-law of the respondent number 2,
Lordship.
respective. Uh, State is a formal party. Is a copy shall be furnished to respondent number one state. This is a formal part. Notice may be issued upon the respondent number two, allowing the prayer of the petitioner counsel in this regard. Further proceedings in PRC so and so pending before learned GMHC test shall remain state till the next date of listing.
JMFC Sunitpur Testpur.
Sunitpur test. I do state board to bold query. List the matter when we should give a date, no? Since it stays there. Yes, next year
My lord,
before Bihu,
8th of January.
8/1.
Oblige, your lordship.
Dead hearing AB 43.
This is 9. Right. Right. No. Last two opinions also, none had appeared actually. And Islam. Case diary is received?
Case diary not received.
Not received. Case diary is also not
They
received.
are not interested to pursue the case. Earlier also since 27, they have not appeared.
Interim is also there.
Can you make it?
Interim was passed in 10/2/2025 only.
Interim may be vacated, if they are not. After some time, then.
After some time. After some time. All of hit on, not just a button. Stop. Dot before full stop. The petitioner, on the last two dates, none had appeared before none had appeared for the petitioner. There's an interim order dated 10/2/2025. It's stopped. Dot. After some time. Forest matter should be taken. If the council is there, he's not there. You're there.
11. Item number 11. Here, Lordship, most of the sections are irrelevant in my case, except section 60 of Assam Forest. Section 60, Lordship. Here, Lordship, punishment is.
Yes.
If the offense is above 1 month, a punishment for the offense is above 1 month, then Lordship, they may arrest. This is the condition. If such person refuses to give his name and residence, then Lordship, we are ready to furnish our name and residence address.
What is the allegation?
Allegation is
Let us read this page 11.
Yes, Lordship, page 11. May I read, Lordship? May I read, Lordship?
Yes.
With reference to the subject cited above, I have the honor to inform you that I would like to produce the following 3 numbers of accused persons who have been arrested in connection with above referred offense for illegal felling and loading of poetries from Joyrampur Reserve Forest under Dhemaji Range, Dhemaji Division, which was detected by me and which was prohibited by provisions under section 24, 25, 40, 41 and 60 within bracket 1 of Assam Forest Regulation Act 1891 Amended Act 1993. Brief description of the offences are as follows. That on 12/9/2025 at about 7 AM, I along with my subordinate staff of Joyrampur Beat Office went to regular patrolling duty at Joyrampur plantation area. During our patrolling duty, we found 17 numbers of khoy trees has been felled and removed away by some miscreants. That so immediately after the incident, the matter has been reported to the higher authority and an FIR has been lodged in Bordoloni outpost regarding the matter. That after an investigation has been carried out to apprehend those culprits involved in the felling and removed of those coir trees from Ziadhol Reserve Forest. The culprits have been arrested, and Lordship, I am seeking anticipatory bail. Lordship. That so on this date, 25/10/2025, as per information collected, I along with the forest officials went to village so and so, Dhemaji. Here names are given, Lordship. Number 1, Basudev Nazari. Number 2, Dhoniram Nazari. Number 3, Samel Marmu. And Lordship, these are the persons. Thereafter, a case has been registered, so and so, of Assam Forest, under Assam Forest Regulation 1891 Amended Act. And number 3.3, that during the preliminary interrogation, the accused person stated that on 12/9/2025 at about 12, Sri Disham Narjari, this is me, Lordship,
Understand.
of Joyrampur PS.
I have understood. So, Mr. Bhattakur,
I want to appear, incident protection may kindly be given, Lordship. I will give my statement, Lordship, regarding.
have you received a copy?
Yes, he may appear, my lord, in the next days.
Fair enough. Very good. Mr. Gogoi and I Bhattakur, Learned Counsel appearing for the Forest Department Wildlife Crimes. The petitioner invoking the provisions of 482 BNSS seeking anticipatory bail with regard to Dhemaji Range Forest Report Number so and so, registered under so and so Assam Forest Regulation 1891. As per the complaint dated 26/10/2025, 3 persons were arrested for allegedly being involved in illegal felling of coir trees.
17 number.
Coir trees, full stop. It is also stated that the present petitioner worked as a wages labor for felling the trees and that he is absconding. Stuff. They submitted that the petitioner is willing to cooperate and record his statement. The learned special, can I record that? No issues. Fairly submits that he can be allowed to render his cooperation to the investigation. Case diary, right? We call for a case diary from the concerned department. In the meantime, in the event of arrest, in the interim, 20,000, 20,000, 4 persons. Okay, 20,000 with 1 surety of the like, to the satisfaction of the arresting authority and subject to the condition that he shall appear before the investigating authority and make himself available for examination.
My lord may fix a date within which, my lord, he may
Pick
appear.
the date.
10 days.
10 days I will appear.
Usually I keep it open 10 days, within 10 days.
Obliged, deeply obliged.
Then we can fix a date late
for CD.
for CD.
January, Lord.
5/1.
5. Obliged, deeply obliged.
Standing at a 9.
10 was, no?
May I please, Lordship? This is 482 application, BNSS Act 2025. Lordship. Someone by number ITSZO 2025.
This GST matter.
Yes, Lordship.
GST matter.
Yes. I have ready, Lordship, and I have already documents.
Who's appearing? You are appearing.
Number 9.
After some time.
Some the PMLA matter is
Yes.
it's invoking 50 of people like PMLA and Prevention of Money Laundering Act. 50. You would be representing the prosecution? No,
Your name shown.
after some time. Who's being shown? Oh, dear. Still. Too late. PMLA.
10.
Ending item 10.
9.
Still on leg.
Still on legs.
44.
44, your matter. Oh. Me to list it. I'm behind the knowledge. Kelly Milia. Hurry us on call.
46.
Problem is piece of 47.
47.
Your matter?
Yes, CDS.
Your matter.
May I please your lordship?
After some time. Do it also. Interim is there, right?
Yes, lordship.
Supplementary 62.
Petition number 1 is on interim bail, Lordship. And Lordship, during pendency of this bail, anti-secretary bail application, charge sheet has been laid, Lordship, showing us as absconder.
Absconders.
Yes.
Why? Interim is there. You should.
The only.
You can appear also.
Yes.
Have you appeared?
Yes, I have appeared, Lordship, because during the pendency of this.
They may not be.
Yes.
Miscommunication.
Yes, Lordship. And Lordship, petition number 1 is on interim and others are not on interim, Lordship.
Petition number 1 is on interim.
Interim, yes. And Lordship, there is a Coros affair also. Lordship, my humble submission, since investigation has already been completed and the petitioners are ready to join in the trial, Lordship, and they may be protected, Lordship.
Well, you have received the case diary also.
No, Lordship, PCR has been received. Tagged.
Or charge sheeted case.
Yes. Basically, Lordship, allegation is petition number 1.
Trial has also started.
Yes, yes.
Trial has started.
Yes, yes.
Evidence has also started.
No evidence not started, but appearance. Lordship.
Appearance. I see. Yes, make your submission, prosecution, then I ask the order.
Otherwise, he is an absconder in the
Charge sheet. Yeah.
that's it. So
Yes.
let him appear and trial court will consider in accordance with law.
No, Lordship, with the AV. Not in a.
My lord, AB, my lord, let
But
him,
similar
appear.
direction, but is there any section which is punishable with life imprisonment? Otherwise, sessions tribal magistrate can definitely give. But anyway, since you are seeking here, the 31-7 order available, 31-7. What? First 2 paragraphs, 3 paragraphs. The petitioner number 1.
Yes.
Sheikh Sadi Ahmed was granted interim bail on 31-7-2025. Stop. Pursuant to which he is stated to have appeared for the for recording his statement.
Yes.
Stop. The case has already been charged sheeted during the pendency
Yes.
of this petition, whereupon scan record was called for and received. Full stop. The case is stated to be at the stage of appearance. Full stop. Considering the completion of investigation and stage of the case, I am of the considered view that subject to suitable conditions, the petitioners should be allowed to remain on, go on bail, go and remain on bail. Accordingly, the interim bail granted to the petitioner number 1 is hereby made absolute. With regard to the other petitioners, petitioner number 2, 3, 4, and 4, 5, and 6, it is directed that in the event of arrest, 20,000 each with the surety of the like amount each to the satisfaction of the arresting authority. For all the petitioners, the following conditions are imposed. They shall be available during the trial and appear before the learned court below as and when required. Number 3, they shall not hamper or tamper with evidence, shall not try to influence witnesses or harass or harm the informant slash victim and their family members. Violation will enter cancellation of the bail. Petition stands disposed, allowed and disposed.
Lordship, since it is a charge sheet, that they.
No, what you do is you appear before the court and then you submit, you're already on the cover of bail, right?
Yes, yes.
So you submit fresh bail bonds there. You submit fresh bail bonds there. It can be done like this also.
Oh, obviously.
Because I cannot direct the court to give bail, right?
Yes.
Consider I can give, but again, the same question will come, sessions triable. So this way you submit fresh bail bonds. That is always better. Fresh bail bonds before the
Bail
court.
bonds.
That will convert your bail into some kind of regular bail.
Yes, okay.
Wait, please, Your Lordship. Well, this item is going on.
Oh, no, one point actually, so I thought since you had submitted, so this thing, yes. But from this person, one OPM is also stated to have been recovered, OPM. So I thought that I must give an opportunity.
Well, the first contention before Your Lordship is that, my lord.
OPM seats is not covered.
Not
and
covered.
That's settled.
No.
Right? So but they're here, there were two kinds of recoveries.
My lord.
If I have not made any mistake in understanding facts,
My lord.
is that two kinds of recoveries for opium seeds and I think opium,
Opium.
only opium. Opium is listed separately.
Yes.
It's in, and what was the quantity? I forgot. You had given me a chart, right? So that is not commercial quantity, right? So
Not commercial.
and it's okay.
No, my lord, there are,
So let us see that fact again. I think.
my lord, if Your Lordship turns to page 20, my lord.
50.33 grams of
My lord,
opium.
here, my lord, there are two items, my lord.
Mm.
This is an inventory, my lord.
Mm.
And so far the seizure is
Page 18.
page 20, my lord, 20, annexure 2.
Mm. Okay. Yeah, this is very clear. Tabular
Yes.
form.
My lord, there are two items, my lord.
That Goremari from the position of Samirul Bonia and Yusuf.
Samirul Bonia and my lord, the
Yusuf Ali.
and Yusuf Ali. And the present petitioner before Your Lordship is, my lord, Lal Badshah Bania, my lord.
What was his for him?
From me, that, my lord, that diary will say because the seizure is not
I
available.
will point out, my lord, seizure list is available, my lord. I will point.
That is, they have correctly given 20B
My lord.
and 21B. Opium.
Annexure negative.
Chart. Opium was entry number.
There are different types, my lord.
Opium per se is 75.
92, my lord, sorry, my lord.
92.
No, before, my lord, going to the chart, my lord, we have to go to the definition, my lord.
Just a minute. No, since it's intermediate quantity, you do not have the restriction of 37. But just we have to be factually correct. 92 is opium. 93 is opium derivatives.
Yes, my lord.
Other than morphine,
No.
heroin, morphine, and these are different. So poppy seeds is not listed here also. Poppy straw is listed. Poppy straw is listed.
Diabetic, my lord, the quantity of morphine only, that will come only after.
Opium is 25 grams
Yes,
and 2.5.
yes,
So here it is 50 intermediate quantity.
yes.
Now the question arises, my lord, my learned friend is jumping from one to another, my lord. First of all, my lord, what has been recovered from me, my lord?
Yes, that is the thing.
That is the important thing, my lord. Then Your Lordship will turn to page 18 for a once, my lord.
Yes. Yes, this is what.
Page 18, my lord. Second paragraph, my lord. Can't hold it up. Second paragraph, my lord. During search his house, that is the petitioner, a total of 12.307 kg of suspected to be opium / poppy seeds crushed Mark so and so. So that was recovered from me.
Which paragraph you're reading? Page 17?
Page 18, my lord, second paragraph.
During search.
During, sir. Yeah, during.
Just let me read the entire one.
Might, might.
I'll read it myself.
Might.
Is to inform.
আপোনাৰ পৰা পাইছে, দুইটা আপোনাৰ পৰা পাইছে। লাল বাদশাহ মিয়া, চিধা
Stating the same.
এইখনত কি লিখা আছে? তাত আপোনাক পইণ্ট আউট কৰি দিম, তাত এইটোৱে লিখা আছে। কিন্তু আপোনাৰ ঘৰত তিনিটা হ'ল ককাই ভাই, আপোনাৰ ফৰিদুল বনিয়া, লাল বাদশাহ মিয়া, লাল বাদশাহ বনিয়া।
Samirul Borpia. It is house with the younger brother of Lal Batsan and Lal Mia Bania.
সেইটো চব। সমীৰ বনিয়া প্ৰথমতে ইয়াৰ ককাই ভাই ইহঁতে তিনিটা। এইটো
Accordingly, ইয়াৰ পৰা।
মই কৈ আছো, on asking Samuel Sowerly, there has been spoken to all. We along with the police party searched the house and premises of Lal Badsha Bania and apprehended one of his relatives, namely Yusuf Ali.
তাৰ পৰাহে পাইছে।
গম পাইছো, হাউচটো কাৰ চাৰ্চ কৰিলে? লাল বাদশাহ
ইউচুফ আলী পকেটৰ পৰা পাইছে, পঢ়া। যোনটো সঁচা কথা কোৱা আৰু। I searched the body, so.
সেইটো হয়।
ঘৰটো
ঘৰটো তাৰ
মই ইয়াত লৈ আহিলে চিফ জাষ্টিছৰ পৰা এৰেষ্ট কৰিব তেতিয়াহ'লে। ইউচুফ আলী বিল পাইছে। ইউচুফ আলী বিলৰ পাইছে।
Oh, it's okay. They've searched the house.
Yes.
It's a common house.
Yes.
And then seized 12.307 of kgs of opium seeds.
Yes, ma'am.
And thereafter, in the house of this person,
Yusuf Ali.
in the house of Lal, again in the house of Lal Badshaw, it is not very clear.
Madam.
They found one Yusuf Ali, and from his pocket 50.33 opium was seized.
Yes, madam. That is my case, madam.
That's okay.
And that Yusuf Ali got bail, madam.
It's okay. In any case, it's an intermediate quantity. Don't have, but these are matters. These are also harmful things. Anyway, he was arrested on.
Madam, this is a AB, my lord. Anticipatory.
AB.
AB.
Actually not justified.
So from me, my lord, only seats were recovered.
Seats were,
Seats were recovered.
but
So-
they were anyway, granting, but these are actually AB is not very suitable for these things.
That's my only seats, my lord.
Heard Indian Dr. Learned Council, 482 bail application, for Manikpur PS case number C76 of 25 under section so and so, NDPS Act. The allegation in the FIR dated 3/7/2025 is on the based on an information. The police searched the house of one Samirul Bania and thereafter the common premises of brothers Lal Badsam Bania within bracket petitioner and one Lal Mia Bania, full stop. And upon such search, 12.30 kgs of opium/poppy seeds within bracket crushed were seized and found kept in a jute bag. Full stop. Yes.
Only I just like to submit one thing, Madam. At this stage, because FSL, I have not yet received.
Yes.
In case of granting, any relief, only interim may be granted till receipt of the FSL. Because in that poppy seeds also,
Okay.
whether
Good
the
idea.
quantity of morphine has been-
Actually, the drugs cases, anticipatory is not suitable much because.
Yes, no, I mean,
But anyway,
in
so
case
but
of
this is
reject,
a legal point is also involved. Fine, fair enough. It is also alleged that upon information given by the said Samirul Bania, the house of Lal Badshaw Mia was also searched, and from there 50.3 grams of opium was seized. The presence of witnesses. Hers was seized, and there one Yusuf Ali was found, and from his pocket 50.33 grams of opium was seized. with regard to poppy seeds, the Land Council submits that the same is not covered by the provisions of the NDPS Act. And the same, that position has also been clarified by case laws in support of the same. Which should I refer? Supreme Court judgment?
Yes, for the state of Himachal.
Nirmal Court. In this regard, the reference has been made to the judgment of the case of State of HP versus Nirmal Court alias Nemo.
Paragraph 20.
2022 Supreme within bracket SC 1081. The cross citation to Didok SCC. SCC citation to Kundo. Nice one, SCC citation. Anyway, 2023 Criminal Law Journal CRLJ 532. Full stop. What was the relevant paragraph?
Paragraph 26, madam.
20. Oh, yes. Sure. The relevant para 26 thereof may be reproduced herein below. Had you heard? It, huh? 26. Reproduced here in the heading. Full stop. With regard to the opium, as prima facie, it appears that as per the FIR, it was recovered from the pocket of one Yusuf Ali after giving him a notice under Section 50 of NDPS Act. Stop. The learned additional PP submits that if bail is considered, then perhaps only interim bail may be given as at present, as FSL report is awaited. First, I find force in the said contention. Accordingly, the CD may be, case diary may be sent back and procured again along with the FSL report after it is available. In the meantime, in the interim, 30,108. His statement has been not recorded.
No.
Not recorded. Appear corporate investigation, appear before IO, not indulge in any illegal activities, including activities violative of prohibited by the NDPS Act.
Within 7 days.
Within 7. Can I keep this judgment?
Well, yes, but yes.
I can return. You may need it also.
No, I have.
Keep a photocopy if necessary.
Well, I'm obliged, madam, deeply obliged.
No issues. It's pending, but take the date.
Fine.
It's pending. Let's
Date.
leave the matter on.
16.
Okay, 16/12. 16. Yes. Done. Capital time, no? Policy. Timing can you really? I say it.
47 timing.
Record. Yes. Record. I mean, 47.
Allowed, I was enlarged on interim protection lordship. Pursuant to the interim order, I appeared before the IO lordship. He was cordless. Can you find the FIR at the state?
His son was implicated.
Yes,
right?
lordship, son, whole allegation against the son.
And son has got bail already.
Yes, lordship, I have annexed the order also, lordship, it says 17.
Diary, well, let's see.
Yes,
Diary
they
says.
received me. Statement recorded.
Statement recorded. Let him go then. 18 last order to para 1, 2, 3. 1, 2, 3. The petitioner was granted interim pre-arrest bail on 18/11/2025, pursuant to which complying with the bail condition, he stated to have appeared before the IO. Stop. And the same is confirmed by the learned additional PP, who also has the case diary available with him. Full stop. The main allegations are against the son of the present petitioner, who has been enlarged on bail already by order dated 27/10/2025, passed by this court in AB 2020 of 25. With regard to the present petitioner, I see no reason to cancel his anticipatory bail. Accordingly, the interim bail is hereby made absolute, subject to the condition that he shall cooperate with the remaining investigation and shall not hamper or tamper with the evidence. Bail petition. Return case diary, posted.
Deeply obliged.
First phale kobo, first phale kobo.
Okay.
Time being 46. 44. 43. 44.
Lordship, as per direction of your Lordship, I have appeared before the IO on 8th of November. I was on interim, Lordship.
As per my instruction, a short sheet submitted in this.
It's a bit of a serious allegation. So, but
Yes. Sir. My prayer before Lordship.
he was not named, no?
Yes, sir.
He is not, he was not named in FIR. He's not named in FIR.
Not named.
But what are the materials? Because POXO is also there.
My lord, short sheet submitted as per my report.
Charge sheet also
Yes,
submitted.
Scan copy may be called for.
You don't have any other information?
Yes, no. It's only the report regarding filing of short sheet on 10/11/25.
Okay, then we can do that, extending the interim.
Can copy may be.
The petitioner was granted interim bail on 23/10/2025. The learned additional PP, Mr. Bodhakur, submits that in the meantime, case has been charged. Therefore, call for the scan case to court, scan TCR within bracket comprising case diary, charge sheet, and other relevant documents from the concerned learned court, which is special Judge POXO, Kamrup Metro Guwahati, right?
Yes.
The interim bail, however, granted by the order dated so and so 23 times shall stand extended till the next date of listing.
On my lord.
Or date, please take the date. I also forgot.
On.
You also forgot.
13th, my lord, January.
13/12.
13/12. 17/12.
Okay. 17/12.
Forty-three, 43.
Next is your lordship, order dated 10 February 2025, honorable court granted interim
Yeah,
protection.
long time back. No?
And,
So, investigation is not completed till now. What of the allegation?
Did you not?
Innova car was stolen. So.
I know, sir, in this case, my name is not in the FIR.
Not in the FIR.
Not in the FIR, and I am only the cousin of Sabina Begum, who is named and accused in the FIR. And
Subina Begum. Subina Begum.
Sabina Begum.
He is the cousin of that lady. Rightly granted information. Diary is come. Or not received.
Updated.
It's taking a long time. Anyway, the petitioner was granted interim bail on 10 to 2025. The present petitioner is stated to be cousin of one of the FIR named accused within brackets Subina Begum, and that he is not named in the FIR. The case diary is not received issue as the bail petition has been pending for a considerable time. The case diary shall be requisitioned positively on the next date. The interim bail stands extended till the next date of listing. This is the matter on. Actually, there's a direction also now, no? It's until and subsequently that all bails should be disposed of 4 weeks or something.
9th of December.
9th of December.
Of this.
9/12.
Binding item 10.
It is not, sir. What to? 53 is 53, no? 53 all, 54 all, 25 all, 46 all, no? 46 all, 47 all, 47 all.
Might be lost.
Who's 10?
Yeah.
Yes.
Page 12 with FIR. The allegation is that might of the petitioner was, he supplied a uniform to the institution, my lord. And uniform, school uniform. my lord.
Yes.
And ultimately what they say, my lord, subsequently they started, my lord, demanding some money, extra money he used to give, then their works will be given to him. That's why, my lord, ultimately I filed a complaint before the deputy commissioner also, my lord. That is also prior to the date of FIR. And thereafter they have filed the present FIR, page 12. Since 2019, he is supplying the uniforms. No complaint, nothing at all against him.
This complaint was raised, FIR is at page 15,
Page 12.
12.
It is dated 30/10.
Page 12.
30th October.
From distribution coordinator. I see this. We don't have uniform suppliers on earlier supply.
Complaint what?
Supply.
Complaint from Page. This is complaint.
I don't
know.
आगे बढ़े। इसे 1310.
There's some allegations are there. What is the backdrop you're saying?
The backdrop, my your lordship, kindly from the deputy commissioner, we have filed the complaint prior to that. That is my lord 29/10. One is my lord page 23. And first one is my lord 13/10. First one. First complaint is page 15. 1/5. Two complaint, SP also I have given complaint. Already blacklisted also, my lord, because of my refusal to supply that here.
There was demand of bribe.
Yes, demand of bribe. I
According
did
to
not
you,
pay,
according to you.
so ultimately I was blacklisted, my lord. Thereafter I made complaint, 2-3 complaint are there, your lawsuits. All are prior to that.
And thereafter, this case was lost.
Yes, thereafter case was lost. And already annexed, my lord, screenshot is there, my lord, we have also made payment also, my lord, screenshot. Page 14, your lordship.
Yes, I've seen this.
Yes, ma'am. Only because of complaint, my lord, to the DC and the SC, ma'am. I think, my lord, nothing will come out, your lordship.
Otherwise, my lord, it seems that earlier, my lord, the present informant, he failed to supply those uniforms. And because of that taking that advantage, my lord, the present accused person, paragraph 4 of the affair, they demanded amount of rupees so and so for not publishing any news against them. It is the main crux of the matter. Initially, informant supplied uniforms, ultimately he failed for this reason.
Yes, that is there, my
Application
lord,
also
because I
filed.
did not pay because
And
of.
now these are the persons, my lord, they, my lord, make some comments, my lord, defamatory, maybe, my lord, some.
And there was some demand also, according to him.
Yes.
Both sides.
Thereafter, these persons taking that advantage demanded money. That is the.
But nothing was paid, my lord.
Anyway.
I did your
What
lordship.
learned senior counsel so and so. I should be assisted by an P. Thakur. 482 bail application seeking prior's bail for petitioner so and so in connection with South Salmara piece 147 of 25 investment protection. The petitioner is stated to be a supplier of school uniforms for a long period. And with regard to some with regard to some failures on his part in supplying school uniforms. Some officials started demanding some money from him, for which he had lost some complaints. Subsequently, on so and so date,
30, my lord, from 30th October, page 12.
yes, what is the date? 2/11.
Top, my lord, top, page 12, top, 30th October.
Yeah, 30/10/2025. The FIR was lodged, giving rise to the instant case with the allegations that the petitioners have been harassing the informant and publishing false defamatory matters on news portals and social media, demanded rupees 5 lakhs for not doing so. Thus, I see that there are allegations and counter allegations. At this stage, it may not be a bad idea to allow the petitioner to appear and record his version of events before the IO in the interest of proper investigation. However, call for the case diary of so-and-so police station, South Salmara, I think. In the interim, in the event of his arrest, in connection with this case, allowed to go on bail of rupees 25,000, one surety, the satisfaction of arresting authority, and subject to the condition that he'll cooperate with investigation, appear before the IO, making himself available for examination. Number 2, he shall not misuse his liberty to commit any illegal activities. He shall not threaten or harass the informant or his family members. Yeah, I usually don't give any date, but you want a date, 7 days, 10 days, whatever. 7, I usually keep it open, putting some fate, 7 days, 7 days.
7/1.
7/1.
7/1.
Short break. You're appearing for this?
Lordship, I am appearing, but they have not received the copy, Lordship.
Is it under PMLA? PMLA matter?
PML.
Or some summon case number, PMLA account. This is issued by the, what is the impugned order? No? Only the summons.
Lordship may fix it next week, Lordship, because I have not received the copy also, Lordship.
So summons, you can be arrested when you appear, because you guide me, because I am not so familiar.
Lordship, I think this is under section 50, which is only for recording this evidence for submission of documents, Lordship. During the process.
You take the copy, you take the copy, then we can fix it on next week.
Next week, Lordship, maybe.
Next week.
Monday.
Monday or not Tuesday, Monday or Wednesday.
Wednesday.
Okay. No problem. The Learned Counsel, your Mrs.
L. Devi, Lordship.
Learned Counsel appearing for the Enforcement Department, Enforcement Directorate. Submit that copy of the bail petition may be furnished. The same may be done so by the petitioner counsel. This is the matter on Wednesday.
Wednesday.
No problem. 3:12.
Timing at 46.
Yeah, please, your lordship. Yes, FIR it is page 12.
46.
And this.
Page 12.
Page 12. So what happened, lordship, on 1/9/25, my lord, I met with an accident, my lord.
Mhm.
And with a, my lord, the Scorpio vehicle, my lord, my vehicle met with an accident.
Mhm.
After the accident, my lord, people gathered there and out of my lord, treat, my lord, I escaped from the place of occurrence, my lord. And thereafter, my lord, On the FIR, it has come to my knowledge that my lord, some amount of my lord, cannabis were my lord found inside my vehicle.
That
That
Maruti.
Maruti
Forms.
Forms, my lord.
Yeah, you were driving it.
I was driving it.
Anyway, let's. AB is no?
AB.
Diary, let's get diary. It is diary. Oh, receipt. Bail.
So, my lord, he is the owner of the vehicle, and one,
It's which
one-
item? It's
item number 46, my lord.
just a minute. Just. I see. Okay. So,
On his vehicle, my lord, 102.056 kg of cannabis recovered, my lord.
10
102.056 kg, my lord.
cannabis.
Cannabis, yes.
Ganza.
Ganja.
Ganza.
Ganja, yes.
So 20 kg.
Yes.
That's
100
why C has been given.
Yes, 102.056 kg.
Quite a big quantity.
And my lord, regarding other vehicle number 9611,
Mhm.
my lord, the owner of the vehicle statement is available in the case diary.
Let me read the FIR once. No? I'll read it myself. I see. So that way, accident and people noticed.
The other vehicle appeared, his statement recorded, but the present petitioner is freed away from the spot till now. He has not.
That's
my
why
lord,
he's filed this
This is in search of the present
Hmm.
petitioner till, but my lord, till now, my lord, the present petitioner should not be apprehended by the police.
But even in anticipatory bail, if 30 commercial quantity, 37 determination has to be made.
Yes, yes. my lord.
So kindly see.
Otherwise, prima facie, it seems, my lord, he is, because from his vehicle, he was driving at that point of time as per the submission, my lord.
No, there will not materials.
Materials.
Hmm.
He is directly involved, my lord. And from the investigation, my lord, now police is trying to find out, my lord, him till now, my lord. The present petitioner could not be arrested.
Is there any material in the investigation that he was driving the car? No, he is fairly submitted, but independent materials. In the statement of That he must have happened in a section accident, then he won't notice who was the driver perhaps. Otherwise, I would have directed to records, but 37 is there, a commercial quantity, very difficult.
Give some protection, my lord, I will appear, my lord.
No, 37, I have to, the court has to see, otherwise the order will not be legal actually. It has to be, there are many judgments, as you know, without complying with the conditions. If you can record that he is not guilty, then prima facie. That is why I asked this question, that I am seeking the materials to indicate that he was driving the vehicle. Otherwise, the owner may not suppose no. Sometimes he might benefit. Suppose somebody is the owner and somebody else is driving. That person might also load something, you know, that owner may not know sometimes.
Yeah, I'm fairly submitting, my lord, that he was driving.
Yes, that's very fair on your part. But that's why I'm saying that I don't want to penalize you only for that. I'm looking for independent materials.
Yes. You may take it after some time regarding that aspect also. I will.
Okay, you look at it because it's an important thing.
Otherwise, regarding my lord, from the, it seems prima facie, my lord, from his vehicle. Why?
Or I do not say anything on 37 and reject the bail. That will keep your options open for the future. I won't go into 37 because it can be rejected. To give 37 has to be passed. But to reject, you may not necessarily have to go into 37 also sometimes, because even as I said, even if 37 is passed, then also suppose it is initial stage of investigation, you may still, the bail may still be refused sometimes. But to give, if when 37 is applicable, you have to pass the test. So you look up, that will be good to you.
I have to show that he appointed any driver that on that day, my
Yes.
lord, but on a particular driver.
Very difficult actually, and without anticipating. Difficult. Anyway, you have a look, see that materials, so that we can decide it very fairly. Yeah.
Lord, may take it up on some other day, my lord.
Other day also can take up if you are not comfortable.
Yes.
Monday.
On Monday. Monday, yes.
Okay. The case diary has been received. However, the learned prosecutor, public prosecutor, needs seeks some more time to look into the aspect of Section 37 NDPS Act. Retaining the case diary list on Monday, what day? One.
Tuesday would be convenient, my lord.
No,
Second.
Tuesday don't fix. I have some difficulties.
Yes, but Monday.
I'm seeking a short. I'll be there, but
Yes.
I don't want to fix Monday. Huh?
Bail hearing BA 20.
May I please, your lordship? The regular bail, lordship. Petitioner is behind the bar for last 378 days, lordship. Lordship, petitioner is facing a trial, lordship, for charge under section 4, subsection 2 and 8 of the POCSO Act.
Amicus is there.
I will have to inform.
Priyanki.
Only contention is that, lordship, violation of 47 and 48.
What is the stage? Yeah, that's okay. But what is the stage of the trial also?
The
Otherwise-
evidence has commenced, but since the trial court is vacant now,
Okay, which trial court?
that the special just POCSO, Tinsukia, lordship,
In Sukia. Second.
vacant, lying vacant now.
Number, additional number one. Also, there's only one now.
Yes.
Margarita. It was, one was, the other one was transferred to Margarita.
Well, going on against the present petition.
Yes, sir.
There are sufficient incriminating materials.
All under POCSO.
Yes,
under
all
POCSO.
POSCO, my lord.
All
He-
similar, lordship. Lordship, may kindly see for a moment page.
But still, we should see it objective.
Yes, page 25,
Every case is different.
page 24, lordship. The arrest memo. The case in which he was arrested originally. Page 25, page 24, arrest memo, lordship. Date and time of arrest is there, lordship. Signature and name of relative, lordship, that is there, Horen Bormon. And lordship, thereafter, page 25 is the inspection memo.
Inspection memos.
Page 25. Then lordship, page 26 is notice under section 47 BNS. Then lordship, page 48 is the notice lordship under section 48. Everything is lordship kept blank. No ground of arrest, no reason of arrest.
Brief of the case is part of this notice or it's separate document?
Which one, lordship?
This one? This one? So upper part is 47 and here,
This is a separate, there's a mistake in the Xerox lordship.
I think so.
Yes, lordship. Contents of some other page.
That's why I appeared like that.
Yes. So lordship, everything is blank lordship, except the lordship case number and penal provision, nothing is.
This is only open now.
Lordship, that is the, I am letting lordship merit lordship. Otherwise not a good case for.
This is only open now.
And I would also, my lord, your lordship may consider it or not, my lord. I would like to point out, my lord, 479 2 of the, my lord, BNSS provision, my lord. If against a person, my lord, 3 or my lord, multiple cases are pending against an accused, my lord, wherein all such sheet, my lord, submitted and trial is going on. In that case, my lord, bail should not be. I may be wrong, your lordship.
No, I think you're right. No, merit bail to it appears to be prima facie a tight case anyway. So, shall we start looking into it?
Yes, 479 is lordship.
479?
BNSS, my lord.
I'll come back to you. Don't worry. I'll come back to you. BNSS. I have come across this section. 479.
In one case, he has been granted bail lordship.
No, I will see objectively. I'll focus on this case.
Lordship.
That is
479.
479 years. Your lordship.
Maximum period for which are under trial can be detained. It's earlier 436, I think.
Yes.
436 A.
No.
Where a person has during the period of investigation, my lord, inquiry or trial, investigation, inquiry or trial,
436A earlier.
under this Samhita of an
You're reading subclause?
1, my lord.
1. Kindly read it again.
Where a person has
During the period
of investigation, inquiry or trial during investigation also, under this Samhita of an offense under any law, not being an offense for which punishment of death or life imprisonment has been specified as one of the punishment under that law, undergone detention for a period extending up to specified for the offense law shall be released on bail, provided that, my lord.
Then next. I think 2. Subsection 2.
Oh, yes, sorry, my lord, subsection 2, my lord. Notwithstanding anything in
This is a-
subsection 1 and subject to the third proviso thereof, where an investigation, inquiry or trial in more than one offense or in multiple cases are pending against a person, he shall not be released on bail.
Then that means this provision of 1,
Yes,
no,
yes.
this will not apply if
Yes.
there are more than one case.
Okay.
That maximum period of detention, lordship.
Maximum.
That will not be applied.
That will not be applied. That will not be applied.
So here in this case.
That is
there are-
confined to only subsection 1.
Subsection. As I understand. Also, accommodable. Okay, let's see. You have received a copy, no?
Yes.
Received.
Translate copy is very much there in the petition, your lordship, page 12 itself. Informant is the mother of
Yes.
your lordship.
He is a football coach.
Yes, your
Football
lordship.
These things are. He was arrested on,
15/9/2024.
oh, so he's been there for a long time. Other cases he has been, I'm not, only for this purpose I'm asked. The other cases he's on bail,
In one case, he's on bail.
others are still in custody.
Next case, he's item 21 is lordship of the same accused.
Grounds of
Right.
arrest.
The third case.
And what is the stage of this case? It's at the stage of trial.
Trial, evidence.
Evidence is going on.
Well, no, could not be taken because of the lordship, absence of presiding officer lordship.
Oh, actually, you said.
Annexure 2 is there, your lordship, page
Page 15.
16, and there your lordship ground of arrest is serially your lordship given your lordship.
No,
That is-
yeah.
that
he
is
has
forwarding
taken this round. Learned prosecutor also will have to guide. He's taken this ground, so we have to see that ground.
Forwarding report is
But the
there,
trial
your
is not
lordship.
progressing, not due to any fault on his part. The court is vacant.
What is
The
vacant?
court is vacant.
Court is vacant.
In such cases, perhaps some arrangement can be made because, especially those who are in custody.
Yes. Only he has been remanded time and again, lordship, by the in charge court.
From the record, Bhattakur, can you show me that, where is that notice?
6.
That's.
6.
Find it, but save me some time. Yes, you make your submissions.
Page 12 of the petition, your lordship. There, your lordship, my son, namely X, your lordship, given as your lordship, he is.
I've read.
underage, your
That is
lordship,
allegation,
your lordship.
FIR.
Yes, I've seen the.
And along with 20 other boys, your lordship, he has gone to participate on All Assam under 15-day night football competition for a club hailing from Harmoti, Lokhimpur. On the last day, your lordship, that is 5th September, the said team was given accommodation of an auditorium of Morning Star Club.
I've read it.
Yes, your lordship, Dumduma. And he stayed at night, your
I was
lordship.
abused.
Yes, your lordship. On 7th September, everyone was sleeping, and the coach, your lordship, that was accused, present accused, your lordship,
So-
Ranjan Borman, took that, your lordship, took that my son while he was sleeping and sexually harassed it, your lordship. He was also threatened it, your lordship, that if he disclosed this matter, your lordship, to anyone or said something to about this matter, your lordship, he would not be able to wear that jersey and boot forever, your lordship. He was given that also, your lordship, treatment. And then, your lordship, my son has not told anything to anyone. On the next date, that is on 8th September at night, your lordship, that the coach again, Ranjan Borma took my son from his sleep and again, your lordship, committed sexual harassment, your lordship. This fact was disclosed by son, your lordship, warden, after reaching Lokhimpur, your lordship. So here, your lordship, he was being threatened, your lordship, if he disclosed this. And moreover, your lordship, he has, your lordship, sexually assault not only once, but twice, your lordship. And thereafter, your lordship, I would like to take you in page 16, annexure 2. Ground of arrest, your lordship, 0.6, straightly towards the 0.6. Grounds of arrest, very below down, ground of arrest is there.
0.6.
And 0.6. The arrested person has confessed about his involvement in this case, your lordship. The present accused already, your lordship, confessed that his involvement is very much there. And thereafter, your lordship, that these 3 cases found registered against him. That is my humble submission, your lordship. As trial is going on, your lordship.
Yeah, that is true on merits, but the trial is not progressing because not due to his fault. That is one problem. But the main thing is that he's seeking bail on these grounds, and it was an arrest in 2024, middle of summer of 2024.
September.
But the notice he has annexed, this obviously does not suffice. This was the earlier format. Nothing is there. But so I just want to cross check from the record. Otherwise, he will have to be granted bail because of these reasons. This is the law.
That is earlier standard format, lordship.
I'll start narrating the facts. In the meantime, you'll cross-check. Hart and so he does for the informant, additional PP. It's the invoking section 483 BNSS, the petitioner Ranjan Burman is seeking regular bail in connection with POCSO case number 102 of 24, the section so and so, arising out of Dumduma PS case number 148 of 24, and which is stated to be now pending before the Court of the Learned Additional Session Judge, come Special Judge POCSO Tinsukia. Full stop. The case arose out of an FIR dated 11/9/2024, lodged by the victim boy's mother with the allegation that the petitioner, who as a football coach had accompanied a team of teenagers, had sexually abused the 13-year-old boy of the informant who was part of that team, and that such abuse was done on 2 occasions. The accused was arrested on 15/9, did I say that? 15/9/2024. We'll stop. The learned counsel for the petitioner submits that though the case is at the stage of trial, but the same has not proceeded due to the court being vacant. The court being vacant. The learned counsel, drawing attention to the relevant documents, submits that compliance with section 47/48 BNSS has not been done. He does learned counsel for the learned amicus appearing for the informant has submitted that there are significant allegations against the petitioner, and that there are also other cases pending against him. Learned additional PP submits that there are sufficient incriminating materials against the petitioner. I have cross-checked the notices from the scan record which is received. The 47 notice may be reproduced here and below. The notices under 47/48 are reproduced here and below. He is very lucky he has to be given bail. Lucky to this extent. Otherwise, so many cases are
Very much there, your lordship.
yeah, but this I'm also helpless from the point of view of victim and prosecution. This has to be followed. So we have to, anyway, trial is the main thing.
Yes.
And if he violates any conditions, then you can always.
There are 14 PWs.
The aforesaid nature of the notices would clearly fail to meet the stipulated standards in terms of Article 22(1) of the Constitution of India and the laws in this regard laid down by the Honorable Supreme Court in Purkasto and Bihan Kumar, which holds the field. The learned additional PP has also drawn my attention to section 479 subsection 2 BNSS, which reads as follows. As it has been held by the Honorable Supreme Court that once a person is found entitled to be entitled to bail on the basis of non-compliance with this constitutional requirements, such entitlement would not be defeated by other restrictions like statutory bars. Next paragraph. In such view of the matter, despite the nature of the allegations and the adverse materials, the accused is hereby allowed to go on bail of ₹50,000 with one severage to the satisfaction of the concerned learned court. Conditions: he shall be available during the trial, not hamper or tamper evidence, shall not harass or intimidate or harm the informant slash victim side in any manner, violation to him. The bail petition stands allowed and disposed of in the aforesaid terms. This is a continuous matter. 21 is also.
21 is also same.
Same ground,
Same ground.
same ground.
21, Lordship, I am appearing on behalf of the.
Informant.
Lordship. There is section 47.
Same ground.
Same.
It does not reflect anything.
Yes, yes.
My objection will be recorded.
Similar allegation.
Mr. Ganguly appears on behalf of the informant and objects to the grant of bail on merits as the significant materials
Well, sir, the same
and
allegation.
against the petitioner. Allegations are same type allegations.
Same type
Similar.
Abuse, sexually abusing
Boy.
a boy, a teenage boy, who was part of a football team, of which the petitioner is a coach.
FIR date different.
Mhm.
Offense date different. In this case, he was shown arrested. On 39/2024.
It was terrible, everyone. You were shown arrested on 39.
11.
13/11,
30/11.
2024.
24.
30th of November.
He's been in custody for a long time. That is also there.
And 48 notice was not issued, Lordship, only 47.
So, I don't know about 47, 48, terrible. On the record, it's there. You need to check it.
No, why? I
Same.
will check. Same.
Same.
My objection may be there.
Yes, yes, objection is there. The bail conditions are there in case of violation. In most cases, heavens is don't fall by grant of bail actually. Main thing is trial. Sometimes it may, but usually it does not. It usually does not. And these are actually also, there is also a term, as you know, called psychosexual disorders. Actually, there's there might be a problem in the mind, you know. It doesn't mean that
Yes,
he
yes,
can take,
yes.
he can become a patient and escape criminal liability. That will not do. But why would someone abuse a child? You know, because the psychology of crime is a fascinating subject. Psychology of crime. It is always there. Psychology.
Administration also. The way in which the entire investigation is carried.
No, notice at that time they did not know. This was the format. This was the format.
He
If
was
it is retrospective in all these
Yes.
cases, they will be ended.
He is also a married person having children.
No, they are also victims in a way.
Yes, Lord.
22.
They are also victims.
Yes, Lord.
Reputation.
Obliged.
Make it, your lordship. Lordship, in this matter, trial court record was called for your lordship. Your lordship, the petitioner hearing is the son-in-law of the informant, your lordship. Your lordship will find the FIR from page 10.
Just a minute. Just a minute. Item 22. Yes, FIR page 10.
Page 10 is the typed copy. Page 12 is the vernacular. From page 14 is the relevant portion, your lordship, vernacular relevant portion. May I read the type copy, your lordship, page 10. With due respect, it is stated that to earn livelihood, my son-in-law stayed in my Kalapani's house and was running a shop at Kotabari. Seeing the opportunity, my son-in-law mixed intoxicating substance in the food of my younger daughter, Mofida Begum, 15 years, and committed wrong things with her and fled away. He recorded his misdeeds through a video camera, and when he started blackmailing my daughter, she narrated it to me. While Sahidul Islam was on the run, I found him in ISBT and brought him to house. It is therefore prayed to kindly take necessary action against the accused person. So, your lordship, this happened between the family, your lordship. They were living in the same house. He is the petitioner is the husband of the informant's elder daughter. And the victim is the younger daughter of the informant.
Sister-in-law.
Sister-in-law. So, brother, your lordship, at this stage, your lordship, instead of going to the merit of the case, your lordship, I will stress upon the detention, your lordship. He is behind a bar since 13/3/25, your lordship. So around 260 days as of today. your
13/5?
13/5/2025. So today is 28/11. So 8 months, 15 days. So around 260 days, your lordship. He's a man of 21 years old. He's 21 years
No,
old.
30, you've written 13/3, if it is not a mistake.
Yes, your lordship.
13/3 or 13/5?
13/3.
13/3.
13/3. 13/3/2025.
Oh, sorry.
So it's around 8 months, 15 days, your lordship. So at this moment, your
Days of trial is going on.
trial is going on, your lordship. So your lordship, he may be allowed to, your lordship, my humble prayer would be that he may be allowed to come out and he may be provided the sufficient opportunity to contest his case, your lordship. There are some materials against him, your
In the
lordship.
family.
Yes, your lordship. I've gone through the record. There are some materials, but at the same time, your lordship, this is a family affair, your lordship.
No,
Yeah.
let us not say that.
Yes, your lordship, there are
It's
also,
very- it is,
there are
uh,
certain allegations. your lordship.
These things can bring disgrace to a family.
Yes, your lordship. There are also.
Entire
certain-
family.
Yes, your lordship. There are also certain allegations that your lordship, there are some, the relationship between the elder daughter and the petitioner was not that good. So that is another aspect, your lordship. That will come in the trial, your lordship. This is unfortunate incident, your lordship.
If true. If
Statement is also available. She implicated my lord, one that my lord pen drive, that video, my lord.
just a minute,
Individuals-
he submitted something, reading paragraph 5 now. You just see if there is any element of this contention, that he was having a estranged relationship. He was estranged with his wife. And to teach him a lesson, they made this story. That is one contention.
Another person who appears to be the boyfriend of the victim, your lordship. So his statements are also recorded, your lordship. There is something, your lordship, fishy.
I don't know, we should not. Anyway, so let us see, otherwise a victim is examined.
Yes, sir.
My lord, yes, her 164 statement is available.
Victim is examined, informant is examined.
Yeah, this is court of exam, evidence station.
You can consider perhaps. He's a silent, write the facts. Heard. 483, invoking 483 basis. Seeking bail in connection with special POXO case 7125. Pending before special judge POXO come metro. Corresponding to Jalakbari
Trial
case.
not yet started on.
125,
25.
25.
Three statement recorded.
Then this is all necessary also. 125 with 25. Under section 65 BNS and grade with 6 of POXO. Trial is not started.
Trial not yet started. My victims 183 statement recorded.
Just for one question.
Charge frame, my lord.
See, because of load, this kind of things is happening. The POXO Act is saying that victim should be examined within 1 month.
Lordship.
It's not the court's fault also, they are overloaded, but then we perhaps need another court. One more POXO court, maybe Guwahati. With 8 months to definitely the,
It was 15 days, your lordship. I counted at
Right,
260 days as of today.
because their time limit for the IOs
Yes.
in POXO.
Charge frame, my lord. Charge framing on the.
So time limits. Charge frame, but not started. And
Victim deposition not yet. I have
no,
not,
no witness examined.
no, my lord, I have not found the record.
Then instead of, then it will be difficult to give, but instead of rejecting, we can ask for status report if this is not, if you think this is complete, then we need not. Order sheet is there. We can-
I will have to again. Order sheet, my lord, I have to-
Otherwise, we
Only
reject
charge
that if
framing
they-
order is there, my lord.
Mhm.
Deposition, I have not. Deposition is not.
183.
present status report may be for. Deposition report. আমার victim-ৰ deposition report কৰিলে নেকি? 183 statement-ৰ কথা কোৱা নাই, deposition charge হোৱাৰ পাছত তোমাৰ statement record কৰিলে নেকি? Victim-ৰ evidence হৈছে নেকি? Victim-ৰ evidence হ'ল।
কোনটো ষ্টেজত কথা আছে? কোন তাৰিখলৈকে আহিছে? Yes, materials. Lot of materials in this stage, it will be difficult. Let us be difficult. Let the exam victim may examine, then we can see again. No. Prima facie, it appears to be authentic nature of the narration. Okay. Stop. The case arose out of FIR dated 12/3/2025, lodged by the victim's mother, alleging that the accused, her own son-in-law, had sexually abused her younger daughter, aged 15 years, and even blackmailed her with some photos and videos. The accused was arrested on 13/3/2025 and in custody. It is submitted by the prosecution that though charge has been framed, but trial has not yet started. So, I peruse the statement of the alleged victim girl recorded under 183 BNSS before learned JMFC, and noted the implications therein. At this stage, the bail petition stands rejected. However, the learned trial court is requested to kindly endeavor to expedite the trial, especially the examination of the important witnesses like the victim, informant, etc. Should we send a copy to the? Yes. You are appearing as amicus? Okay, sorry. You make your submissions. Anything? Objection? No objection. No, actually, that's all. I'll not record that. So let us say you are not objecting to the bail. But anyway, let it remain. After some time, we'll see. But should we send a copy of this bail order to the court?
Yes.
How will they come to know?
Yes.
Hmm? Yes, a copy of this on bail order may be sent to the learned trial court for kind information. They are disposed. Easy. It is.
23-24.
I am appearing in item number 24, madam.
Arrest.
Item number 24, madam.
Kindly mark that copy.
Yes, page 102.
Mark the copies. 104.
102, madam.
Just I'm seeing 104.
102.
2.
10.
Yes. 2020.
Yes, my lord. Here he has been arrested, my lord, on 14/12/20.
Okay.
And my lord, charge sheet, my lord, citing 12th number of
He's
witness.
arrested on 14/12/20.
Yes, my lord.
Long time he's been in custody.
Yes, my lord. And my lord, charge sheet laid, my lord, it's 10/6/21 charge sheet.
Okay. And trial?
And my lord, thereafter, my citing 12th number of witnesses.
Okay.
Till date, 5 witnesses have been examined.
Time. The other 50A notice is also there.
That is not available, my lord.
That's not available. You filed an objection?
Yes, they have filed an objection.
They filed.
We have not filed our objection.
No, you have filed an objection.
Okay, so it will be filed.
I have received. my lord.
It has not been filed, but. Like on our please.
Running page.
Running page 112, my lord. I have received the copy, my lord.
Next time, I do give one source of care. Paragraph of 8. Next paragraph.
ऐसे repeat कौन कौन बोलते हैं?
Paragraph to another.
Commercial quantity, right?
Commercial.
Mm.
Prolonged incarceration.
And notice, you are taking notice grounds. Otherwise, we'll have to see this. In any case, he has been in custody for a long time. Course also it should be given. Otherwise, expedited should be. NDPS trial can be completed within 1 year for framing charge.
Yes, ma'am.
Not many witnesses.
Various reasons for.
Mm.
Delay
Yeah.
cannot be the ground. Recently, I.
Delay may not be, if it is, if it is attributed, delay may not be, maybe due to many factors. Yes. Only we may be responsible for this. Some court also may be responsible. Partly, it may be due to load, due to many things.
System.
Many things system, but if you use effective date management technology, then these things can be tackled very, much better, I would say. Anyway. Okay, no, NJ Dr. and Decca Learned Council first, NCB. The petitioner invoking 483 BNSS is seeking regular bail in connection with NDPS case number 27 of 21, corresponding to NCB crime number 17 of 20 under 17 of 20, pending before the learned special judge, before the session judge, this time. Special judge, Kamrup Metro, Guwahati. Full stop. The accused is stated to have been arrested on 14/12/2020 itself. And charge sheet dated 10/6/2021 listed 12 witnesses and
5.
12 witnesses.
5 were examined.
11 witnesses. I'm not writing that. 11 witnesses. Charge was framed on 17/1/2022, and so far 5 witnesses have been examined. The Learned Council has drawn my attention to the notices under 50. Notice under 50. Have you flagged that?
But that is not in the record.
No, 50 notice.
Yes, I couldn't find lordship.
Could not find. But no, you have annex, no?
Yeah, I have an page 102.
Isn't it? But it should have been available, isn't it? But without,
It's not there, lordship.
should we ask? Should we ask for it? But it should have been. That's why many unnecessary things are not required from the scan case record. Actually, only the directed documents. Should we ask for it?
Otherwise, I have
Oh,
given.
no, of course. No question of not paying your
There-
document,
and
but
there-
just a duty
My
to
lord,
cross check.
And they are also not
They
disputing.
are duty and.
They are also not disputing that. They are fine with it, but that's fine.
আচ্ছা they file an
I have
affidavit.
it.
Finding a late affidavit.
Fine.
কেন করে affidavit বিচাৰি পোৱা নাই?
Hey.
Running case I'm not finding. The said notice is annexed with the petition. And maybe reproduce during the.
Their reply to against paragraph 10, my lord.
They have denied that in a sense.
Denied, but
Violation, the notices underway duly issued. But whether this, should we, don't we think we should, is Deka, should we cross check it once? This unnecessarily, it remain pending, but don't you think, of course, there's no question of not believing his notice. That is absolutely true, but your duty, my duty, you know. This must be the one, obviously, but it should have been, it unnecessarily increase our work and keep it pending. The to reproduce urine below full stop. In para 9 of the affidavit filed by the prosecution, it is stated that the notice under section 50 CRPC as it existed then was duly issued. And that duly issued, memorandum of arrest prepared, an intimation of arrest was given to the father of the accused, but that notice is also not there. The notice annexed to the petition bears the purported signature of the arrestee and it's dated 14/12/2020. It is a copy of the certified copy issued from the court, and it is annexed as Annexure 9 and certified to be true copy by the learned advocate B. Ahmed. The learned prosecution does not dispute that the said notice is not the one under, is not the notice under 50 CRPC. The aforesaid nature, aforesaid notice clearly would not meet the stipulations laid down by the Honorable Supreme Court in so and so cases vis-a-vis Article 22(1) of the Constitution of India. The grounds of arrest are required to be in reasonable detail and specific to the accused person. And these have to be furnished not only to the accused person, but also his nominated person / relative in terms of the constitutional mandate, full stop. In the event of such violation, the continued under trial detention of the accused shall become untenable, and this would be so even if there are other statutory restrictions on grant of bail, full stop. No judgment has come to notice or has been placed to indicate that the principles laid down in the aforesaid supra are not retrospective. Next paragraph. Accordingly, in the given situation, the accused person is required to be given bail, granted bail at this stage, full stop. In any case, he has been in under trial detention since 14/12/2025.
20.
Sorry, 20. Did you? Yeah. 75,000? 75,000 with 1 0 like usual conditions. NDPS 2 did violation.
I'm obliged.
The other one is same.
Otherwise, it's same, she is appearing, same, co-accused. I'm obliged.
Okay, notice will be same, almost same.
We could not annex the notice. Arrest memos are annexed with the petition. But similar, same FIR, same arrested on the same.
You have annexed the notice?
No, lordship.
Also, you could not annex the
No,
notice. Then
But-
we had nothing actually with regard to this.
We are also on the ground of long incarceration, lordship. It's
Same,
almost
same date of arrest. Same
Okay.
date of, everything is
same
same.
date of arrest.
But, you would agree, I think that we'll need one notice at least regard this, at least from your side or their side or
Lordship,
both.
then we
I
can,
did.
we can
Well-
go with the long incarceration, lordship.
No, 37 is there. 37 is very, very stringent, but yes, 21 is applicable, no
Not
doubt.
for 5 years. Half of the minimum punishment, lordship. And not even halfway through the trial.
But why don't you? The notice must be there. How come it is not there? Should we have a look again? This, but you must have seen it thoroughly. Yeah. No, we did not find, but their notice, at least maybe we'll find their notice. No, you didn't find.
I will check again, lordship.
Hmm?
I will check again, lordship.
You can say, but I don't think we'll get.
But I don't think lordship, if one notice is not available, the other will be available, but
No, unlikely. But
they were arrested on the same day.
yes,
the
but
same
it should
place,
have been
lordship.
there, no? But without the notice, how can I say that it is not? I know it is. It will not be. It will be like this only. Almost, we are sure, 99%. It will be like this only. But we cannot say. No? Fact. It's a fact.
In that case, lordship, 5 years
So-
inside the, behind the bars. Without significant progress in the trial, lordship.
Anyway, we'll see this thing. Kindly check it once. Half done has, but it's not. You can just complete this. Huh?
My lord,
Notice is not there.
my lord, they served a copy during the trial, lordship. In that entire copy, we found that the notice as per section 50
Yes.
and 50A is not there, lordship.
But
It is
notice
the
is,
record.
it
It is
is,
in the record, lordship.
it is in the record.
Record, lordship.
Which record?
It's their record they provided to us, lordship.
You found it?
No, it is not there on the record, lordship. It
Okay.
is their record, lordship, can go through it. It is their record, we are conducting the trial, my lord. It is the trial court record they provided to us, lordship. Yes.
It is by mistake, I think this notice has not come here.
White flag is there. White flag. Apart from that, lordship,
Hey, what is his name? Liton Das.
Litandas and Sapan Malakar and Pradeep Dey. My lord, the 4 persons were arrested at the same place at the same time from 2 trucks, lordship.
Pradeep Dey.
Pradeep Dey and Litandas. 4 persons were arrested as per final complaint. Kindly go through that, lordship.
Right.
Final complaint, lordship, will find at page number 15.
Similar one. So what should I refer to this? This is the record received from?
From the side of petitioner, lordship, because during the trial, they have provided to us, lordship.
You have not annexed this copy with the
Oh,
petition?
we did not annex, lordship, but is the
It
facts,
should be-
lordship.
No, you are seeking bail on this ground, so it should be annexed anyway. I will not penalize you for that, but it
No.
should be annexed, isn't it? It's such a
We
big
can
thing.
provide this right now,
So
this
anyway,
Xerox copy with us, lordship.
but it must have come, it should have come from the court actually, but they must have missed it.
But
It is not available.
my lord, fact is that if it is not followed with 4 persons arrested together, lordship. Then with the other 3 also, they have not provided this same way, lordship.
Anyway, these are old documents, old documents now. These are.
And my lord, one more thing is that Apex Code also considered, lordship, we have annexed the copies. The long incarceration at page number 84.
Pradeep Dey and Liton Das. the notices under section 50 CRPC furnished to the accused petitioners may be reproduced here in below. Full stop. What is this? Their petition. This is a different order.
My lord.
Different order. Any submissions from your side?
Lordship, reasonable for.
Lordship,
You complete.
5 persons were arraigned as accused in this case, Lordship. Then 1 person moved before the apex court, Lordship. We have annexed the copy at page number 84, Lordship. Para number 3 is there, Lordship. The petitioner has been incarcerated in jail for a period of more than 4 years. In our case, because of that reason, Lordship, the apex court has granted bail. And Lordship, in our case, Lordship, the petitioners were inside the jail for about 4 years, about 5 years. 4 years, 11 months, 12 days. So, my lord, only after they have cited 11 numbers of witnesses, Lordship, among 11, only 5 witnesses examined into their Lordship.
Okay.
They decided in Ravi Prakash case, Lordship, which override the rights under section 37, Lordship, Article 21.
You have the judgment.
Yes, Lordship. And section 50, Lordship, is there. The Lordship already just now, Lordship granted bail to the co-accused.
Upon perusing the aforesaid nature of the notices, I will not repeat them. Take it from there. Apologies. Let me see this judgment before I come to observation. Your Prakash is there. Ravi Prakash. There.
In para number 3, para number 3. Para number 4.
I've seen.
Lordship. Last 4 lines.
So this is the well settled. Yes.
Lordship, with regard to first point regarding section 50 notice, that's even my humble submission. Is sufficient information was disclosed to the petitioner, and at this point.
You have stated in your affidavit also.
Yes, Lord. And Lordship, this honorable court in case of Jitul Ali, consider same notice was there, and court has come to a conclusion that this is sufficient information provided under section 50.
Which case? Jitul Ali? This, which notice was there?
Paragraph same.
But this notice is inadequate, right? This one is inadequate.
Document you should see.
50A notice is not here.
This is inadequate.
No, Lordship, my submission, Lordship, because the same notice was issued by the NCB in other cases, that was considered by the honorable court come to a conclusion that the information provided in the notice issued by the NCB is a proper note. Sufficient information will be provided under section 50. Lordship, with regard to.
Oh, it's this one. No, I forgot some my order. This, yeah, this is in this kind of case. This, yeah, I've seen this. Different view was taken. Different view was taken.
With regard to login termination, recently Supreme Court on 7th of November 2025. I'm giving the judgment.
Stop. This, see, one thing is that I think we have to hold back this because it has been held in the judgments on which the petitioner side is relying upon. Behind in that judgment only, it has been held that wherever this contention is made, that if notices not been compliant, the prosecution has to be given a chance to show. So since the records, it's not available, let us ask for the trial court to send the notice from the site, isn't it? Because this is not, they have not even annexed the petition. They have not annexed.
But my lord, same thing will happen if Lordship, because if notice is not there, then how can this?
No, notice has to be there because this is your notice.
No, my lord, if notice is not there under section 50 and 50A, then my lord, trial court cannot send it, Lordship. If it is there, they could have shown in their final complaint, Lordship. Final complaint is.
How did this notice come then?
My lord, this notice is not as per the
No,
record.
that is a different thing.
But
See, we have to cross check. See, I am not disputing. I never dispute.
But my lord-
Council has submitted, it must be true. But see, the prosecution's duty, you'd appreciate, prosecution's duty as well as the court duty.
but let them show
That,
through.
yes, it has to be cross checked
let
from
them show
there.
Through the, from
No,
the.
it has not come here.
My lord.
It has
from-
not come here.
From the record, they can show this lordship. It is in the final complaint. If it was there, then it would be in the final complaint lordship. Final complaint, I have annexed at page number 15. There is nothing lordship regarding compliance of
See,
section 50 and
see, the
58.
thing is that, look at it reasonably, you are seeking bail in a commercial quantity, case on the basis of, technical bail, not going into the merits, on the basis of a notice, and though that notice has not been annexed, how can you say that the court should not ask from the prosecution? The prosecution must be given an opportunity.
Record is there and.
Because I don't want to go into this thing. See, there are many principles laid down, no doubt. The interplay of the statutory restrictions in 21, it is there. These are this is reiterated in many institutions. But one of the best exposition you see, paragraph 17 of PA Najib. They have explained that how at what point the Article 21 trigger point. What is the trigger point where Article 21 will prevail over the statutory restriction? Again, that cannot be put in any mathematical calculation. You're right. So say average 5 years, 4 years, and then let's say at that time already at the beginning, the court has said that if we start applying Article 21 at the beginning, then it will amount to totally nullifying the statutory restrictions. But if the person has already undergone incarceration, trial has not proceeded, then perhaps the Article 21 will gain upper hand, and then the court goes on to say in paragraph 17 of Najib that this is how we shall harmonize Article 21 and statutory restrictions, right? So, ma'am, please, you just hold on for a few days, 5 days. I'll get it next week. We'll specify this thing. You have submitted. I of course trust you completely, but they have to be given. They have to do their duty. We have to do the procedure. So. Let us do this
The
thing.
complaint is in the record, my lord.
Where is the record? Show me.
Complaint
Page?
lordship, I have annexed, and it is received by the registry lordship in the.
No, where is the complaint? Show me.
Complaint is at page number 15, lordship. Start from 15, lordship.
Your petition?
In my petition
Okay,
till.
let us see that.
52, 15 to 52. In the 15 and 52, there is nothing regarding compliance of the section 50 and 58.
No, where is the notice? Is it available here?
No, it is their complaint against us.
No, without seeing the notice, how can I say
But
whether it
if
fulfills
they
the
have
mandate?
complied, if they have complied.
No, that is not the.
If the complaint-
Without seeing
Lordship is
this
correct.
screen, can you say what is there in the screen?
No, lordship is
Can you-
correct. Lordship is correct, but it.
I have
it
been
should
very
be-
reasonable with you.
It should be, it should.
See,
be-
you are seeking bail on, straight away someone can say, court can say, you are seeking bail on 50. You have not annexed the notice. So still I am giving you a chance, isn't it? But this is off the record, not from you, your side. So it's
Lordship,
okay, I
lordship,
believe it, I
lordship,
trust, I
any
keep
day.
it.
Any day, lordship.
But I cannot,
Lordship may please any day.
yes, but you cannot expect me to pass an order,
No, lordship.
over
Supreme-
37.
Lordship, Supreme Court already hold that the lordship, this is a long incarceration in the order I have annexed in the same case.
That
Lordship.
will go into the first your contention, then needs to be seen.
Lordship passed just now a order in favor of the accused who is arrested in the same day,
Because-
same time.
No,
lordship.
because his notice was annexed.
But lordship, in the same way, they have arrested same place,
Then-
same time, lordship.
Then where is your notice with the
But
petition?
If it is
Now,
not,
have you filed?
no, if
No.
it is not compliant
Uh,
with that case.
Then
how
I'll have
can
to,
it be,
no,
lordship?
I'll have to record then, because this is not, you have to be, you have to make reasonable submissions, this
Lordship
thing-
may fix any deadlock.
I don't get irritated, but you have to make reasonable submissions.
Lordship,
You are seeking bail in a commercial quantity, bypassing merit only on the basis of notice, and you expect me to
Merit-
assume the notice.
long incarceration is there, lordship.
Yeah, that aspect is there.
Which is held by the apex court.
That is there. That is there. But you are,
Already apex court
but the, in
decided in this case.
but in the co-accused bail, on the bail of the co-accused was on the.
So apex court also hold
No,
that.
no, in the
Apex court
no,
hold that regarding.
no, this case, this particular case in the co-accused moved by Mr. Datta, bail was granted only on Bihan Kumar,
That lordship.
on Bihan
No,
Kumar.
my lord, I'm not only on that lordship. Lordship, I'm other part also is there apex court lordship. That hold that it's a long incarceration. In 4 years, 4 years, I am in 5 years lordship.
I am myself showing you the law, para 17 of Najib. Next time we'll see that.
Najib
Also
lordship.
reflect that.
I have gone through Najib lordship.
Para 17, there's no better exposition than that.
But yeah, here minimum punishment is 10 years. He has completed 5 years lordship.
What minimum punishment 10
Yes,
years,
yes.
extendable to life imprisonment.
Minimum punishment is 10 years lordship.
Extendable to life imprisonment.
Life imprisonment extended 20 years, Lordship. Which may extend to 20 years.
These are very serious crimes, alleged crimes, commercial quantity of
Obviously,
drugs.
we are not on that. Why they could not finish the proceeding, Lordship?
One of the contentions of the petitioner side is the non-compliance with the notices under section 50 and 50A of the CRPC. The other contention of the petitioner side is that despite being in under trial detention since 14/12/2020, the trial has not yet been completed, and so far only 4 witnesses have been examined out of the listed 11 witnesses, full stop. However, the copy of the said notice has not been annexed with the bail petition, and a notice under 50 has not been annexed with the bail petition, full stop. Though the scan record has been received, the said notice also could not be found in the said notice, in the said record, full stop. In the case of Prokastor and Bihan Kumar, one of the points laid down is that whenever a contention regarding non-compliance with the notice, these mandatory notices is made, the prosecution is to be given an opportunity to show, to throw light on the said compliance or otherwise. In view of the same, issue of fresh requisition to the learned trial court to send a scanned copy of the notice under section 50A CRPC, which might have been given to the accused at the time of his arrest, and send the same to this court expeditiously. In case the said notice is not found in the TCR, in the original TCR, the same shall also be intimated to this court. This is the matter on 5/1. Only 1 week. Okay.
Can it remain as part heard, Lordship? Already heard the matter.
Part heard. Well, no problem. It's fair.
Lordship.
List the matter as part heard.
Obliged, Lordship. In the meantime, I will file the additional affidavit with this.
You can file an affidavit. That would be good idea.
Obliged.
So sometimes some things, notices can be, we are human beings. Some notices, some documents can be left out, but it's always better to bring it on record. It strengthens my case.
Obliged.
When you take back this, this is very important for you. Please take back. Fifth, 5/1. 5/12, sorry. 5/12. 5/1. 5/12. Next week.
Item number 64.
Supply. Yes. Yesterday's matter.
This is an application under 4832 BNSS. My lord, the brief background of the case is, my lord, a particular agency called yes, Mohanlal Jain and Partnership Firm, my lord. It was entrusted with the job of contract of, my lord, constructing the Moran bypass in Upper Assam. Apparently, my lord, the agency completed the work. However, my lord, there was some delay in the execution of the work. As a result, there was a requirement of getting, my lord, time extension and work completion certificate. Now, it is in that context, my lord, the petitioner and his officials is to visit the office of the chief executive of the NHIDCL in Guwahati. Now, the allegation in the FIR is that the officer, that the regional chief executive, he demanded some bribe for, extending the time and for furnishing the work completion certificate. It is in that context, my lord, a trap was laid down, whereby, my lord, the person called, the naam to kaise litu? That a bail. No, other. One Mr. My lord, the officer, we are not concerned with the officer. We are concerned with the, my lord, partner of the firm. Now, my lord, he is no way involved. only allegation attributed to him in the FIR is that they intended to bribe him in order to secure the extension certificate and the work
Right.
completion certificate. Now, my lord, despite the laying of a trap, they could not catch anybody red-handed. As a result, what happened? As per the FIR, my lord, the person who allegedly parted with the bribe, my lord, he was caught only when he was outside.
Okay.
So therefore, he approached this honorable court despite he was arrested. He has been enlarged on bail.
He was arrested.
He was arrested
time-
and he has been enlarged on bail.
Trap procedure.
Yes. Now, my lord, coming to the partner of the firm who is seeking this pre-arrest bail. Now, as far as he is concerned, my lord, I couldn't find anything substantial allegation against him either in the FIR and in the post-trap memorandum, my lord, no role has been attributed to him. However, my lord, CBI has filed an affidavit opposing the prayer for bail. In that affidavit, if your lordship would kindly come to page 65, just para 23, this is what, I'm sorry.
No, it's okay. Affidavit, where is the affidavit? Thus. It's come on record. Must have-
Written objection filed by them.
By now it has, yesterday it was not on record. Must have come, affidavit, CBI. CBI objection.
Right?
Must have come by now. Yesterday it was not there.
I'm handing over a copy. In the meantime, they can copy.
It's not come on record.
Yesterday I have filed it. Maybe it has not come on record.
If requisition is not given, it may not come. Milord will kindly come to page 65, Milord, of the copy which I have handed over.
I have one extra copy.
This
If your
is-
lordship
this
please-
is-
Please give
This
it.
is-
No, thank you.
Please come to page 65, para 23, Milord. That the averments made in paragraph 4225 are distorted and misleading, hence denied. It is submitted that there are sufficient evidence in the form of recorded telephonic conversation which has categorically established that the accused petitioner Amit Kumar Jain and Binod Kumar Jain, representative of Mohanlal Jain, indulged in corrupt and illegal practice and conspired with so-and-so. In furtherance of the conspiracy, Binod Kumar Jain had handed over a bribe of rupees 10 lakh to so-and-so for granting extension of time and issuance of completion certificate in respect of the road construction work executed by his company. My lord, regarding the allegation in this objection that the petitioner Binod Jain conspired with that engineer, my lord, that is an aspect which will be revealed at the court time of trial, my lord. But as far as the allegation of payment of bribe is concerned, my lord, this honorable court had the occasion to deal with that allegation in the order which your lordships will get at page number 50 of the bail petition. Now, if your lordships will kindly come to paragraph page 58, my lord. 8 to এনেকে লিখিছে 6 জেনেও পায় নাই
It's okay, no problem.
page 58 para 16. Now,
Yes.
this is what this honorable court, a coordinate bench of this honorable court could notice while considering the other bail application. It is seen from the records that the accused applicant is the manager working in the partnership firm, namely Mohanlal Jain, located in Kolkata, which is involved in executing certain EPC contract in Dibrugarh, wherein NHIDCL is also a party representing the government. It is also seen that the accused applicant was in fact arrested from the office of the NHIDCL located in Guwahati. However, as far as the version of CBI in the post-trap memorandum, that is so-and-so, the ground of arrest of CBI provided in the notice under 47 and 48 of the BNSS, there is a striking difference relating to the time of interception and arrest of the accused applicant by the CBI team. It is apparent on perusal of the aforesaid document that CBI in the ground of arrest mentioned that the accused application was caught red-handed while bribing the co-accused, namely so-and-so. However, in the post-trap memorandum of recovery and seizure, so it has been specifically mentioned that the accused applicant was apprehended while he was coming out of the chamber of the aforesaid co-accused. Therefore, these two versions of the CBI do not say the same thing, and therefore it cannot prima facie be ascertained at this stage as to which version of the CBI story is correct. In case of trap relating to bribery, sequence of events is of utmost importance, and there should not be any missing link relating to demand and acceptance of bribery. In the instant case after perusal of the material, this court prima facie could not find any substantive material which reveals that accused applicant was in fact found at the time of delivering the alleged amount of bribery to the accused co-accused. However, this court would like to refrain from going. My lord, in these facts, my lord, to hold me guilty of conspiracy is too far-fetched, my lord. Therefore, my lord, the law will take its own course. But what is the requirement of my custodial interrogation, my lord? Whatever materials are there. Now, my lord, in the objection, various judgments of the Supreme Court has been quoted, my lord. My humble submission understanding is, my lord, a judgment is an authority for what it actually decides. Every sentence in a judgment is not to be read as a statute. It all depends upon the fact. In the facts of this case, my lord, in my humble submission, my lord, perhaps the custodial interrogation is not called for. And Lordship was pleased to call for the case diary.
Yes.
My humble submission is, my lord, Lordship will go through the case diary.
I'll go through.
And prima facie, my lord, there are no materials. Therefore, my humble submission is, my lord, I should be extended the benefit of, my lord, a prior basis.
Please, your lordship. Before I will start with this case, the very first my contention is it is not
Can I
maintainable.
retain this?
Yes.
It is not maintainable at this stage because it is a very infant stage and the investigation is not yet completed. Rather, it is going on. To review,
Maintainable. Maintainability is another issue.
when it is in the infant stage and
It's a
the
question of merit.
very objective of the PC Act is to check the corruption. And to that intent, the Parliament has made this law to check the corruption, and therefore the amendment has come under section 8 and 9, and thereby the private person has also been incorporated under PC Act. Your
Abatement.
lordship, yes. Your lordship is well aware of the fact.
We are all
And to
learning
that
at the time.
effect, since it is an economic offensive, and I'm going through the fact. Admittedly, he is a manager of that partnership firm, and he was sent. And any investigation, if it is conducted by any institution, there must be a cogent evidence. Unless and until there is a cogent evidence, any institution is not going to lay down any trap. Maybe it is a one part that it is not red-handed. However, the fact remains there. The amount has been recovered from the drawer of the public servant. And the person who has given, he is coming out from the office, and on the interrogation or on asking, he admittedly said, yes, I have brought this 10 lakhs of rupees and I have given. On his instance, this recovery has been made, 10 lakhs of rupees. And thereafter.
The Highway Infrastructure Corporation official has been arrested also.
Yes.
During the
He-
trap.
Yes. And the Binod Jain, who was granted bail, he was granted bail only on the plea that he was sick. He is suffering from liver cirrhosis. At the time of moving the bail, the main pressure was given that he was medically unfit and suffering for the cirrhosis. However, CBI has made all arrangement for his treatment. So this cannot be taken as parity. Why, your lordship? Because he is the manager, admittedly. Just now my learned friend said, he is a manager. He has to act on the order of his master. And who is the partner of this firm is Amit Jain. Amit Jain is the partner. And Binod has stated in his statement that this amount is given to me by so and so. And during the course of interception, the investigating agency has already taped the interception, and then only the trap has been laid down. Unless and until there is any cogent evidence, no institution will let down a trap. It is an organization, and with the intent to check the corruption, economic offenses, this legislation has been made. And if in such an infant stage, if any protection is granted to the accused, in that event, it is very difficult to get the qualitative evidence. and notice has been given to them. Warrant has been issued to the Amit Jain, but he has put his house under lock and key. Not only that, he has switched off his mobile. He is not found out. His whereabout is not known. Had he been, there is no suspicion. Why he is evading the prosecution agency? Why he is not cooperating? If he has not sent that 10 lakhs of rupees, that he is not supposed to evade the agency or investigation, he could have come forward and say, yes, this amount is not given by me, straightway. He could have proved. Why he is avoiding? He is avoiding from last 14/10.
Apprehension of arrest.
He could have filed anticipatory bail in the court's law. And the Supreme Court has been shut off. He says that before coming to the High Court, they could have come to the proper channel. Recently, it has been given by the Supreme Court.
That is an ongoing debate. actually.
Yes.
But
And,
concurrent jurisdiction is there
Concurrent
in
jurisdiction.
the statute.
Okay,
Statute is there, yes.
I'm not going to dispute anything. However, the public servant, he has already filed the application before the court below. To that effect, your lordship, the Supreme Court in the latest judgment, there are a number of judgments. And with regard to the parity, why parity cannot be granted in this case, parity cannot be granted. Admittedly, he is a manager and the Amit Jain is the partner of the firm. And the work is not completed, he has to take the completion certificate as well as extension of the time. That apart, parity cannot be granted. This and coming to the judgment, there are a number of judgments your lordship I am giving. In the recent, in the economic offences, it has been given, I have made it serial. 1, 2.
With regard to the alleged offense, with regard to the, generally speaking, the
Yes.
offense of bribing,
Yes.
you know, that is a section 8 is the
Yes, section
relevant
8.
section.
I am coming to that, Your Honor.
This has been after amendment. This is-
Yes, after amendment.
Hmm.
This has been incorporated in 2018 and the very objective to check the, this bribery. Section 8, I am coming to that, Your Lordship. Section 8, offense relating to bribing of a public servant. Any person who gives or promise to give an undue advantage to another person or a person with intention to induce a public servant to perform or improperly a public duty or to reward such public servant for the improper performance of public duty shall be punishable with imprisonment for a term which may extend to 7 years or with fine or with both. Thereafter provided clauses are there and the another sections are there. Then 9 is also there. Offense relating to bribing a public servant by commercial organization. Admittedly, it is a commercial organization. It is a partnership firm. Where an offense under this act has been committed by commercial organization, such organization shall be punishable with fine if any person associated with, it's associated with. It's a very point to be noted, Your Lordship. The associated means Binod has been, Binod is also associated with the firm. He is acting as a manager. Person associated with such commercial organization gives or promise to give any undue advantage to public servant intending to obtain or retain a business for such commercial organization or to obtain or retain an advantage in the conduct of the business for such commercial organization, provided that it shall be a defense for the commercial organization to prove that it had in a place adequate procedure in compliance of such guideline as may be prescribed to prevent person associated with it from undertaking such conduct. And thereafter the definitions are given with regard to the commercial organization, business and this. So this has been included just to check the corruption, economic offenses only. The intention of the parliament has to be looked into and given a weightage. And moreover, without interception and still digital evidence is required to be taken out. And if at this stage, if any protection is granted to the accused person, the qualitative evidence cannot be come out. And apart from that, they have every link with the officials of the organization like project officials, subordinate staff, vendors, and third-party recipients.
There are materials to indicate demand, right? Because as you know, that's in our law, that's whether, and that's a position that there has to be demand.
Demand.
Mm.
Telephone call is there, intersection is there,
Mm.
that has to be retrieved.
Mm.
Demand and recovery. Recovery is also.
Because a person can
Yeah.
unilaterally
Yeah.
try to, give a bribe also, but that
those-
is not our law. The law, there has to be a demand. Right.
The interception, and that interception is allowed. Yeah, and in view of the interception,
Yes,
this
yes.
trap has
I
been.
get your
let down.
point.
Otherwise, there would not be a accuracy of the time, your lordship. Because the time was fixed and interception was there. That is why maintaining those time and everything, this trap has been made. And the person, Binod Jain, has already admitted that this amount has been given by the firm to hand over to the official of the government. In fact, he said that this amount is required to be given through Amit Jain. Because of some he's preoccupied, it has come in the interception, then Binod Jain has to come. Otherwise, such a big amount, usually the firms, they usually give themselves. However, he is working there as a manager and must be working on the power of attorney or delegation of power is there. He has given that amount.
Right.
And at this stage, it is just in the trial stage. And in fact, from last 1 month, it is not located. Consequent upon which our investigation could not be able to complete. To reveal the truth, whether the amount has been given through the firm or Binod has given in his individual capacity, or interrogation is required, and without custodial interrogation, qualitative evidence could not be revealed out. The moment protection has been given, all digital evidence will be destroyed and qualitative evidence won't come. It is anti-corruption cases and the documentary based evidences are there that can be easily destroyed, or witness may influence. If protection is there, definitely he can influence because he is not a new firm. He is working since long. He is having a number of connections. And when he is having a number of connections, or either way, whether he has obliged somebody, definitely those persons will oblige him also on his dictates. It is a vice versa. So at this stage, if any protection is granted, that means total PC Act implementation of the PC Act is difficult.
No, I mean,
Because investigation is not at all possible in that event. When investigation is not at all possible, truth won't come. And when truth won't come.
investigation will be possible, but your contention is that it may be hampered.
It may hamper.
That is what you are
Definitely,
saying.
it will hamper because he is avoiding, even after given a notice, warrant has issued, he is avoiding, he has switched off his mobile and he is not located. Otherwise, the CBI people, they can locate him, but he is hiding somewhere. It is very difficult to locate from last 1 month. That itself shows there is a certain suspicion. Had he been clean, he could have come forward and said, yes, this 10 lakhs is not, I have not given this 10 lakhs. What is the problem? Investigating agencies are not cruel. They will take out the truth. They are also human beings. And I'm coming to this, your lordship. This is the new judgment of 2025 given by Mrs. Bella Trivedi, Justice Bella Trivedi. And thereafter number of 24. There you go. That is the judgment. I have made all serial here, 1, 2, 3. So in my first judgment coming.
Well, this is their serious fraud. This judgment is.
I have made all serial. There are 10 judgments and 1, 2, 3 I have made it. You know.
This demand and acceptance. Neeraj Datta is there, no? This constitutional bench. Constitutional bench. That's the. Anyway.
This is admissible, your lordship, in the trial court. And there are many things which are the question of trial. Those are the question of trial. Whether demand is there, whether acceptance is there, those are the question of trial. At this stage, what is required? It is a prima facie case.
Will it hamper your investigation if
Definitely.
if the person is allowed to record his statement, keeping this pending? His version of events can be recorded. I'm just asking, taking your opinions. That's not easy for you to straight away, I know.
4%
Difficult to concede
protected
also.
by the order of the Honorable High Court, definitely is not going to reveal anything. This is already implied, definitely they are not going to reveal anything, the moment they are protected. Of course, after investigation, they can come at any point of time for getting the bail. There is no problem. But Supreme Court has allowed custodial interrogation in economic offences.
Yeah.
And in the meantime, they subject to filing of second application or third application, whatever may be, but custodial interrogation is allowed. Supreme Court in number of cases, custodial interrogation is allowed to get the qualitative evidence. Unless and until there is evidence, how the investigating agency will
Yes.
proceed with the case. Then
Custodial interrogation,
close the report.
custodial interrogation within the ambit of law, within lawful
Yes,
means
within the ambit of.
could mean, something leading to discovery, confrontation. These things, it can obviously, as is, conventionally thought that custodial interrogation can never mean custodial violence, though custodial violence still prevails in our country, unfortunately. But custodial interrogation, today, if a the investigating agency is seeking custodial interrogation, its reasons have to be something like that: discovery, confrontation, which may not be possible which may be possible, but it may not be fully possible.
7 of the evidence yet, I have not seen. But at this stage, if any protection is granted, they will take it granted that nothing will happen if they will shut their mouth. And in the meantime, they will influence the witnesses and distort the documents, destroy the digital evidences. It is very easy. When the technology is very advanced, it is very advanced stage to destroy also.
Yes.
Very easy to destroy also. It is having both merits and demerits. Your
Yes,
Lordship.
no doubt.
I'm coming to my first judgment at page number 21. With regard to the 438, direction for grant of bail to a person apprehending arrest.
Where?
When any person has reason,
Para
page number 21.
of the judgment,
Yes, Your Lordship.
serious fraud investigation of
Yes,
that
Your
one,
Lordship.
Aditya Sharda.
Yes, Your Lordship. That is with regard Aditya Sarda.
Para 15.
Para 20, no, page 24.
Okay, I'll come.
The case of serious fraud investigation.
Page 24 and page. That is at page 21, Your Lordship.
21.
Section 438 CRPC.
Oh, yeah, yes, I was on that one.
Page 21.
Yes. Yeah.
Direction for grant of bail to a person apprehending arrest. When any person has reason to believe that he may be arrested on an
This is
accusation
a
of.
statutory section. We can skip this.
Yes. Then and clause number 4, where the accusation has been made with an object of injuring and humiliating the applicant by having him so arrested, either rejected the application forthwith or issue an ad order. And then I'm coming to page number. Jagan Mohan Reddy, page number 24, Your Lordship. Page number 24. That is Y.S. Jagan Mohan Reddy. Below. Page 24, last paragraph, Your Lordship.
Yes.
Y.S. Jagan Mohan Reddy. Economic offences constitute a class apart and need to be visited with different approach in the matter of bail. The economic offences having deep-rooted conspiracies and involving a huge loss of public fund need to be viewed seriously and considered as a grave offences affecting the economy of the country as a whole and thereby posing a serious threat to the financial health of the country. And while granting the bail, the court has to keep in mind the nature and accusation of the nature of evidence in support thereof, the severity of the punishment which conviction will entail, and the character of the accused, circumstances which were peculiar to the accused, reasonable possibility of securing the presence of the accused at the trial, reasonable apprehension of the witness being tampered with, the larger interest of the public and the state and other similar consideration. Thereafter, Your Honor, this is the paragraph of the Supreme Court citations. 20. Unfortunately, in the last few years, the country has been seeing an alarming rise in the white collar crimes, which has affected the fiber of the country's economic structure. Incontrovertibly, economic offenses have serious repercussion on the development of the country as a whole. In the state of Gujarat and Mohanlal Jitamal, it has also realized the same thing. Then I am coming to page number 27, Your Lordship. Para 11. Page number 27, from the second paragraph. The High Court has committed an error in granting the anticipatory bail to the respondent number two, accused ignoring the proceeding under section 82-83. There are a number of paragraphs which this court has relied, and mainly that is Jagan Mohan Reddy, Your Honor.
Yes.
And now I am coming to the Satinder Wala and serious fraud and investigation. My judgment 2. I'm going through only the relevant section, Your Honor. My judgment 2, I have given the number over the Satindra Wali and serious fraud and investigation.
Okay.
This is similar to our case. Present petition has been filed under section 482 of the Bharatiya. Para is 50, page number 6.
Yes.
Keeping in view the material on record, nature of allegation against the applicant accused and other attending factor circumstances of the court, this court is of the considered opinion that no case for grant of anticipatory bail is made out, and accordingly the same is stand dismissed. And thereafter all the narration is there. In this, Your Lordship, page number 5 is also relevant. Page number 5, last paragraph. Now I am coming to another judgment. Nikita Jagannath Sethi. This is also all 2025. Supreme Court has taken very seriously these economic offenses, and that is why a number of occasions denied the anticipatory bail. And this is also 2025. Nikita Jagannath Sethi. Section 438, Section 482, pre-arrest bail, grant of, case registered for offenses punishable under section so and so, so and so. Anticipatory bail is an exceptional remedy and ought not to be granted in routine manner. And para 21 is the observation. In the wake of the discussion made herein above, the impugned order dated 19th June 2024 passed by the High Court is hereby quashed. High Court has given the anticipatory bail, Your Lordship, and that has been quashed. It is reflected in paragraph number 21 of this judgment. High Court is hereby quashed and set aside. The anticipatory bail granted to the private respondent in both the appeal is hereby cancelled. The accused respondent shall surrender before the trial court within a period of 2 weeks from today. They shall be at liberty to apply for regular bail. It's a very clear. Which shall be considered as per law subject to the right of the investigating officer to seek police custody and remand. That is also one rider has been given, power has been given to the investigating officer, subject to the investigating officer to seek police custody and remand. Now I am coming to my fourth judgment, Your Lordship. Srikant Upadhyay, it is still similar to our case. I have already written the para number and in both, para 24 and 26. This is also section 438, read with section 82-83, anticipatory bail. If anyone is declared as absconder, proclaimed offender, in terms of section 82 CRPC, he is not entitled to relief of any anticipatory bail. Power to grant anticipatory bail under section 438 CRPC is an exceptional power and should be exercised only in exceptional cases and not as a matter of course. It is object is to ensure that the person should not be harassed and humiliated in order to satisfy the grudge or personal vendetta. Here your relevant paragraph, Your Lordship, may be seen. 24. Paragraph 24, we have already held that the power of to grant anticipatory bail is an extraordinary power. Though in many cases it was held that bail is said to be a rule, it cannot be by any stretch of imagination be said that the anticipatory bail is the rule. It cannot be the rule, and the question of its grant should be left to the caution and judicious discretion of the court, depending on the fact and circumstances of each case. While called upon to exercise the said power, the court concerned has to be very cautious, as the grant of interim protection or protection to the accused in the serious cases may lead to miscarriage of justice and may hamper the investigation to great extent, as it may sometime lead to the tempering of distraction of the evidence. We shall not be understood to have held that the court shall not pass an interim protection pending consideration of such application, as the section is destined to safeguard the freedom of an individual against unwarranted arrest, and we say that such order shall be passed in imminently fit case. At any rate, when warrant of arrest or proclamation is issued, the applicant is not entitled to invoke the extraordinary power. Certainly, this will not deprive the power of the court to grant pre-arrest bail in extreme exceptional cases.
Okay.
And I am coming to the order passed by this honorable court, Honorable High Court by Justice Ranjan Pathak.
And this judgment, Ramesh Bhavan
No.
Rathore.
No.
This
Fifth
was-
one, fifth
you're not
one,
going on?
fifth one.
Yes,
Ramesh Rathore, that is with regard to the parity, your lordship.
okay.
That parity cannot be granted in the criminal cases. Or Ramesh Rathore is.
Depends on the facts. Anyway,
Now I am coming to my fifth judgment. This is passed by this Honorable Guwahati High Court. Para 31, your lordship, operating. The Honorable Supreme Court in the case of CBI versus Vijay Sai Reddy, while granting bail, the court has to keep in mind the nature and accusation, the nature of evidence in support thereof, the severity of the punishment which conviction will entail, the character of the accused, circumstances which are peculiar to the accused, reasonable possibility of securing the presence of the accused at trial, reasonable apprehension of the witness being tampered with, the larger interest of the public estate and other similar consideration. It has also to be kept in mind that for the purpose of granting bail, the legislature has used the word reasonable ground for believing instead of the evidence. So at this stage, evidence, we cannot go through the evidence. Prima facie case has to be seen in two. Now I'm coming to the paragraph 32, which is relied upon by this honorable court in the case of Y.S. Jagan Mohan Reddy versus CBI. Economic offences constitute a class of apart and need to be visited with different approach in the matter of bail. The economic offences having been deep-rooted conspiracies and involving huge loss of public fund need to be viewed seriously and considered as a grave offence affecting the economy of the country as a whole and thereby posing a serious threat to the financial health of the country. This is given by our honorable court. I am coming to the another, your lordship. That is also of 97th judgment of 6. Page number 2. This is more important and it is relevant to our case, your lordship. Anil Sharma, CBI versus Anil Sharma.
just two.
I have given serially 1, 2, 3, 4 in class.
Yes, go ahead. ma'am.
This one is 6th. We find force in the submission of the CBI that custodial interrogation is qualitatively more elicitation oriented than questioning a suspect who is well ensconced with the favorable order under section 438 if the 438 of the code. In this entering many useful information and also material which would have been a concealed succession and interrogation would elude if the suspect person known that he is well protected and insulated by a pre-arrest bail during the time of interrogation. This is very important and it is relevant to our case, Your Lordship. Very often interrogation in such a condition would reduce a mere rituals. The argument that the custodial interrogation is fought with the danger of a person being subjected to third degree methods need not be countenanced, for such an argument can be advanced by all accused in all criminal cases. The court has to presume that the responsible police officer would conduct themselves in the task of disentering offenses, would not conduct themselves as an offender. This is very important. We need to have a qualitative evidence. And when protection has been given, definitely they are not going to reveal anything, Your Lordship. The another judgment, that is 7, Your Lordship. Srikant Upadhyay, State of Bihar, that is 2024, page number 2, Your Lordship. After extracting section 438 CRPC, it was further held therein thus. The above provision make it clear that the power exercisable under section 438 of the code is somewhat extraordinary in character, and it is to be exercised only exceptional cases, where it appears that the person may be falsely implicated or where there are reasonable ground for holding that a person accused of an offense is not likely to otherwise misuse his liberty. The moment he will be protected, definitely he will misuse the liberty. It is economic offenses. We need to rely upon the digital evidences as well as documentary evidences. And all that will be destroyed the moment he will be protected, Your Lordship. Now I am coming to page number 3, Your Lordship, the relevant paragraph. When the court grants anticipatory bail, what it actually does is only to make an order that in the event of arrest, the arrestee shall be released on bail, subject to the terms and conditions, taking note of the fact that said power is to be exercised in exceptional circumstances. This is of Supreme Court 2010, 1 SSC 679.
This one,
This is at page number 3 in Srikant Upadhyay judgment.
page number 3.
Page number 3. Paragraph number 9, Your Lordship.
9, yes, I'm on there. You're on.
So 2010 SSC 679, and that it may cause some hindrance to the normal flow of investigation method when called upon to exercise the power under section 438 CRPC. Court must keep reminded of the position that law aids only to abiding and certainly not its resistance. By saying so, we mean that a person having a subject to investigation on a serious offense and upon making out a case is included in a charge sheet or even after filing of a refer report, later in accordance with the law, the court issues summon to a person, he is bound to submit himself to the authority of law. It only means that though he will be still at liberty, rather in his right to take a recourse to the legal remedies available only in accordance with the law, but not in its defiance. We will dilate this discussion with reference to the factual matrix of this case. However, we think that before dealing with the same, a small deviation to have a glance at the scope of application of the provision under section 82 and so and so. Thereafter, it has been distinguished with the bail condition and anticipatory bail. It's not that. इसमें बहुत ज्यादा है. Now I am coming to Your Lordship, P. Chidambaram versus Directorate of Enforcement. This starts with para 55. Your Lordship, I have given the page number and paras. All the page number I have given, but I am 55, 59, 62, 63, 64, 67. Everything is distinguished along with the citation of the Supreme Court. But I am coming to the most relevant. It is 67 at page number 22. To curtail the time, Your Lordship, I am coming to the most relevant one. That is at page number 22, 67 paragraph. Ordinarily,
Para 67.
Para 67. Otherwise, 55, 59, which I have given in the cover page,
Yes.
all those are relevant one. Ordinarily, arrest is a part of procedure of the investigation to secure not only the presence of the accused, but several other purposes. Power under section 438 CRPC is an extraordinary power and the same has to be exercised sparingly. The privilege of the pre-arrest bail should be granted only in the exceptional cases. The judicial discretion conferred upon the court has to be properly exercised after application of mind as to the nature and gravity of the accusation. Possibility of applicant fleeing justice and other factors to decide whether it is a fit case for grant of anticipatory bail. Grant of anticipatory bail to some extent interferes in the sphere of investigation of an offences, and hence the court must circumspect while exercising such power for grant of anticipatory bail. Anticipatory bail is not to be granted as a matter of rule, and it has to be granted only when the court is convinced that the exceptional circumstances exist to resort to the extraordinary remedy. Similarly, your page number, para 70, page number 23. Para 70. We are conscious of the fact that the legislative intent behind the introduction of section 438 CRPC is to safeguard the individual's personal liberty and to protect him from the possibility of being humiliated and from being subjected to unnecessary police custody. However, the court must also keep in view that the criminal offense is not just an offense against the individual, rather the large societal interest is at stake. Therefore, the delicate balance is required to be established between the two rights, safeguarding the personal liberty of an individual and the societal interest. It cannot be said that the refusal to grant of anticipatory bail would amount to denial of the right conferred upon the appellant under Article 21 of the Constitution of India. Thereafter, other recitals are there, your lordship. I am coming to 73. Paragraph 73, page 24. Observing that the arrest is a part of investigation intended to secure a several purpose in Adari Darshan Das state of West Bengal. Ordinarily, arrest is a part of process of investigation intended to secure the several purpose. The accused may have to be questioned in detail regarding various facts of motive, repression, commission and aftermath of the crime and the connection of other person, if any, in the crime. There may be a circumstances in which the accused may provide information leading to discovery of material fact. It may be necessary to curtail his freedom in order to enable the investigation to proceed without hindrance and to protect witness and person connected with the victim of the crime, to prevent his disappearance, to maintain law and order in the locality. For this or the other reason, arrest may become an inevitable part of the process of investigation. The legality of the proposed arrest cannot be gone into an application under section 438 of the code. The role of the investigation is well defined and the jurisdictional scope of interference by the court in the process of investigation is limited. The court ordinarily will not interfere with the investigation of crime or with the arrest of the accused in cognizable offense. An interim order restraining the arrest, if passed while dealing with an application under section 438 of the code, will amount to interference in the investigation, which cannot at any rate be done under section 438. So our investigation could not able to proceed because of his avoiding of appearance. This is the most important part in this case. He is the prime accused in giving the bribery, and because of the telephonic conversation, this trap has been laid out and we have to retrieve the digital evidences. Now I am coming to another petition that is of 2020.
Arrest is a part of investigation, no doubt, but now it has undergone almost a generational shift. Even the IOs having to be trained. Earlier, in the earlier years, you'd always have that all my investigation is complete, only arrest, only the accused remains to be arrested. Now the objective is effective investigation, and if you can undertake effective investigation with minimum under trials, minimum arrest, nothing like it. That's the goal actually. With high conviction rate.
Yes.
These are the parameters of judging the criminal justice system, right?
Yeah. Liberty has been given.
Yes.
as a fundamental right. When the liberty has been misused, subsequently all this new judgment has started coming
Yes, sir.
because
No,
it is hampering the investigation.
Because
And
the,
it has
because
come. And
the
there are
journey of liberty
Yes.
has also traveled its,
Yes,
it
yes.
also,
And
had
that's why this type of
traveled this distance today.
Yes.
Today, we have come with this constitutional values 22-1. We didn't know this. This was interpretation. But anyway, but
judgment has come up by the Honorable Supreme Court just to check the corruption because it becomes.
true. That's a very, very serious matter. No doubt.
Legislation has come to that effect only.
White collar crimes, definitely alleged crimes.
Alleged
against this
crimes.
person.
So I am coming to the Devon.
No, yes, then you come to this.
This is
Other
nine.
matters also there. You should.
Judgment number 9.
Keep it concise, madam. Because, many matters are there also. Many matters are there also. Keep it concise.
No, citation.
Tell the citation, you are not.
It is already there in the
These are-
online.
no,
Nothing is.
No, these are,
I can see.
no, these are not, they don't have
Maybe,
citations.
but, all
They are
cases
from
merits.
India Kanun website.
They
actually.
cannot make
These
it
are-
hurriedly.
These are not, they don't have citations.
Everybody is sitting, but.
Otherwise, these have citations. Now we have if you
Which
take out
Supreme
from the
Court
website
has
of
seniors.
Honorable Supreme Court, it has the neutral citation. Then you can give SCC, we have to look up.
Yes.
Mm.
No, it has come from this scan, your lordship, scanner is there. And this is the Davinder Kumar Bansal, para 31, page 15, your lordship. Page 15. This is from the Supreme Court side, your lordship, the latest judgment. Relying on all the previous judgment.
Yes. This is on PC Act.
PCA,
Okay. It's a recent judgment, right?
recent judgment, and it has relied all the previous judgment.
Not
Page
much.
number 15, your lordship. And this is 72 of the judgment of the Supreme Court. Corruption is an enemy of the
Where,
nation. Page number 15, this is 72. However, this 72 is given in the paragraph number.
No, I'll
30.
find out. No, don't worry. 15, 31.
In 30, this has been quoted in page 15. Corruption is an enemy of the nation and tracking down of corrupt public servant. However, high he may be, and punishing such person is a necessary mandate under the PC Act. The status or position of the public servant does not qualify such public servant from exemption from equal treatment. The decision-making power does not segregate the corrupt officer into two classes as they are common crime doers and have to be tracked down by the same process of inquiry and investigation. Then paragraph number 31, this is relying the Neera Yadav and Central Bureau of Investigation, Europe. Every country feels a constant longing for good governance, writers, use of power and transparency in the administration. Corruption is no longer a moral issue as it is linked with the search of wholesome governance and the societal need for reassurance that the system functions fairly, free from corruption and nepotism. Corruption has spread its tentacles almost on all the key areas of the state, and it is an impediment to the growth of the investment and development of the country. If the conduct of the administrative authority is righteous and duties are performed in a good faith with the vigilance and awareness that they are public trustees of the people's right, the issue of lack of accountability would themselves fade into a insignificance. Then again at page number 16, your lordship. Para 61. That is the internal para. Tackling the corruption is going to be a priority task for the government. The government has been making a constant effort to deal with the problem of corruption. However, the constant legislative reform and strict judicial action has still not been able to completely uproot the deeply rooted evil of the corruption. This is the area where the government needs to be seen taking unrelenting, stern and uncompromising steps. Leading should think Leaders should think of introducing a good and effective leadership at the helm of affair. Only then the benefit of liberalization and the various programs, welfare scheme and the programs would be reached to the mass. Lack of awareness and spine attitude of the public has all along been found to be the advantage of the corrupt. Due to the uncontrolled spread of consumerism and fall in the moral values, corruption has taken deep root in the society. What is the needed is a reawakening and recommitment to the basic values of the tradition rooted in the ancient and external wisdom. Unless people rise against bribery and corruption, society can never be rid of this disease. The people can collectively put off this evil by resisting corruption by any person, however high or so. Paragraph number 32. In the overall view of the matter, we are convinced that the High Court rightly denied the anticipatory bail to the petitioner herein. The petition is accordingly dismissed. So High Court has already granted the anticipatory bail, which has been dismissed by dismissed by the Honorable Supreme Court. This is the latest judgment relying in all the previous judgment. Devendra Kumar Bansal. This was the last, Your Lordship. And I have not given with regard to the Rathod, number has not given, that is with regard to the parity, Your Lordship.
No.
Parity cannot be granted.
Yes, I have noted.
Granted. My humble submission before Your Lordship.
Parity depends on the facts, always.
Depends upon the facts. And here parity cannot be granted. Moreover,
Yes, yeah.
his status, Vinod Jain's status is totally different. He is manager. He is acted on behalf of the Amit Jain. And to reveal this truth, we need to have a qualitative evidence by a custodian interrogation. And if any protection is granted, the total object of the PC Act will be vitiated, Your Lordship. And not only that, the total investigation and so long what are the investigation has been done, that all get vitiated, Your Lordship. Because our investigation could not proceed. He is avoiding. One public servant is already arrested. He is in the custody. Vinod Jain is granted bail. Of course, he is the manager. Now, who is the main accused person? It is Amit.
Co-accused.
He is the main person who is doing the work with the National Highway. He is the contractor. And he is avoiding the investigating agency. And from last 1 month, we are trying to locate him, but he is avoiding. And at this moment, if the pre-arrest bail is granted, definitely he is not going to reveal any truth. And he will destroy all the digital evidences, documentary evidence, and anti-corruption cases are totally based on the documentary evidences and digital evidences, because nowadays technology is very high. Everything has been digitized. So at this stage, my humble submission before Your Lordship, that agencies should be allowed to complete their investigation by denying this anticipatory bail.
Lord, I'll give you a 5 minutes reply, Lord. I think my learned friend was repeating the same thing again and again. Of course, she has the liberty, my lord. I'm not saying she can't. Now, my lord, basic question is, my lord, in the name of qualitative evidence, whether a benefit which has been conferred by the statute can be denied to a citizen, but if otherwise it is, my lord, due to him.
Yes.
Now, for example, my lord, please come to section 8 of the PC Act, under which I am sought to be charged.
Yes.
Any person who gives or promises to give an undue advantage to another person or person with intention to induce a public servant to perform improperly a public duty, to reward such public servant for improper performance of a public duty. Amala, let my learned friend show from the FIR, pre-trap memorandum, post-trap memorandum, the CD, that prima facie materials to constitute section 8 is present. If it is present, certainly Lordship will deny me pre-arrest. My lord, we cannot read judgments like statute. Supreme Court has time and again said, don't read judgments like a statute. A judgment is an authority for the proposition that what it actually decides.
in a given facts of the case, the observations may be apt and relevant, but it does not bind all the cases. Is it the proposition of law that in an economic offense, 438 or 482 is not to be invoked? And my lord,
In that case, it has to be abolished. Like it, no, I'm not saying, I'm just saying that like 18A of SEST.
Yes.
But still there, a small window is there.
Even then, my lord,
No,
windows have been carved out.
The point is that a small window has been left out for
Ah.
if there's no prima
Yes,
facie
this
case.
small window
Yes,
is there.
but what the trust of the principles laid down is that the threshold is higher. in case
Yes.
of economic
But your
offenses.
lordship has said a very, very significant thing. The theory of liberty, my lord, has traveled long ahead, my lord.
Yes.
Now arrest is not the rule.
Mm.
Arrest only in a trying circumstances. In a case of this nature, after the trap is laid, everything is on. What is left, my lord? Now, which is that allegation that I gave or
That I
I
cannot say. Of course,
promised to
that
give?
is your
Yes.
contention.
No, like end of the day, it boils down to that. When can I pray for a quashing? When can I pray for a bill? When I establish before the court of law that prima facie offences, materials to constitute the offence is not there. No, but I am not seeking parity from that order. I have read that order to show what are the materials before the authority, the investigating officers. Para 16, I read to show there was nothing against that gentleman against whom the allegation was that he gave the bribe. Now, where is the demand? And demand, it must emanate from a direct evidence. And that material must be in your city.
Section 8 of the PC Act,
but
does it
that's-
criminalizes the act of unilateral bribing? Unilateral, no, I'm just saying, because because just correct me, kindly educate me, because
Yes.
last couple of years I'm a little out of touch with PC. This law, which it has its share of critics, this law, that there without demand and acceptance has to be there,
Ah.
because corruption dynamics are more complex than that. So if the demand is essential, then how does 8 fit in? I'm just trying to learn, because 8 seems to be the criminalizing the act of unilateral bribing. I'm trying to persuade you to take a bribe, isn't it? But
So
that
that is why abatement has.
Otherwise-
also been
otherwise it was
independent-
abatement earlier.
independent section.
it was an
Section 12.
abatement.
Abatement. Abatement has been also made an independent section
Yes.
after amendment of the PC Act, your lordship.
Sorry, please continue.
Punishment for amendment, section 12. It has been made independent also.
Yes. Yes, sir. Senior counsel, please continue. You can complete.
Therefore, my humble submission is, my lord, my learned friends' views are, with all respect, I'll submit, are very regressive, my lord. This is not how law is to be. I know she is defending a brief, but that does not mean, my lord, she will cite 1220 judgment to show that anticipatory bail should not be granted. Where is it written that if the materials are not there, then also bail should be rejected? Our case is, here is a case, there are no materials, no demand, no nothing. Your affidavit is para 23. What have you stated? How can you go beyond that? It is the investigating officer whom you are representing. What the investigating officer has said in para 23. You cannot argue more than that. You're in para 23. What does it say? Let us read it once again, my lord. Page 65. That the averments made in paragraph 4 to so and so are distorted, misleading, and denied. It is submitted that there are sufficient evidence in the form of recorded telephonic conversation which has categorically established that the accused petitioner Amit so and so were indulged in corrupt illegal practice and conspired with so and so. Now, where are the materials? Where are the materials which were brought incorporated in your case diary?
Case diary is very much.
Yes, so that is your duty.
This
You need
part
not
is-
read all these
this
judgments.
part-
Your duty is to place this. And where is the demand? See, you have already done your part. I am giving a reply. Please don't
Okay, please,
disturb me in between.
I'm not disturbing you.
So therefore, my humble submission is, my lord, I don't think to decide a bail petition, my lord, 1213 judgment needs to be cited. End of the day, my lord, it's a very simple proposition. If I am in a position to demonstrate that the materials constituting the offense is absent, then perhaps, my lord, I am at liberty to pray for a bail. And I know, my lord, it's a discretionary relief. End of the day, court may grant, may not grant, that's a different aspect.
Okay.
But to make an argument, the all-pervasive argument that anticipatory bail it does not lie in an economic offense matter, with great respect, I will submit, is not correct. More so, my lord, having regard to the materials of the case. Therefore, in my humble submission, it's a fit case, my lord, where lordships will extend the benefit of pre-arrest bail to the petitioner, my lord. Because, and I'll cooperate with the investigating. In any case, my lord, after the trap is over, I do not know what investigation is left. And and another aspect is, my lord, these are materials which my learned friend herself has said, my lord, that these all based on documentary. If it is based on documentary evidence, why my custodial interrogation is necessary? What is this, my lord, qualitative evidence? Or by inducing you want to extract something, that is something which Constitution permits.
Anyways.
So the FIR has been given just for the purpose of inquiry into a matter. So investigation is not yet completed. How we will come to the conclusion where there is a demand of money or acceptance of money? That part is not yet completed because he is avoiding.
Anyway, I'll look into it.
Could not able
I'll
to
look into it.
interpret the Amit Jain. So this part we cannot able to investigate. It is still under investigation. Who is the prime accused? Who is avoiding? And unless and until he will come forward, we cannot come to the conclusion where there is a demand or acceptance. And with regard to the demand and acceptance, it is the matter of trial. Here we need to see only the prima facie case and seriousness of the matter. We have not yet come to the conclusion because of the infant stage, and we could not able to
Yes,
interpret
yes.
the person.
I get your point. Fine. Chamber.
CD
Take
is
some time now.
CD is there.
You have given me a lot of materials for homework, so I will try to do. But just, you know, we should, no. Why should you be sorry? But yeah, no, you're very experienced. I have fullest respect for you. But believe me, as a student of law that day, I was discussing with one of my senior judge that, you know, doctors nowadays tell patients, you know, that you can look up the net, but don't overdo it. He has, I myself face that, you know, because when you do, because nowadays in our present world, there's information overload. Tremendous information. Earlier generations managed very well without that, but still, hats off to them. Tremendous. So one doctor told me, if you look up too much of the internet, you'll feel every disease you're having. You know? So don't have limited judgments. You know, every judgment is entitled to immense respect. You know, all the various judgments. But youngsters, especially young, we should also guard against, you know, information overload. Because if we have to look what is the authoritative point, you know, on that
Yes.
point, what is the law on that point, and whether it holds the field. That might have been reiterated in 100 decisions. Because otherwise what will happen is that you know, all these, our contentions, pleadings, everything will become longer, judgments will become longer, and you know, the whole process is, you know, so much pendency. So this aspect, I feel, you know.
The process of development, how it has relied the previous judgment and how
Yeah,
there
yeah.
is changes.
So
and why
some of the
frequency changes.
so we have to look, you know, for
Why
those
certain-
judgments which concisely discuss previous judgments.
Restrictions are there.
Yes.
It has come in the latest judgment. Otherwise, liberty is always there. But sometimes liberty has curtailed to come.
No,
to
that
the
is always an interplay. Liberty,
Sorry, latest judgment.
liberty is sacrosanct, but it does not, you know, we all agree, you know, we all agree, we all know it does not exist in a vacuum.
Intent of the
There's
latest
always
judgment.
interplay with societal interest. Liberty is a very sacrosanct value. You know, it is the value of liberty is probably truly felt by people who do not have liberty, who live in systems where there's not much liberty, isn't it? So that is the value of liberty. We are lucky to have, you know, a system. We have constitutional values. That's the thing. But anyway, of course, crimes and all these are very serious things. But so for youngsters, actually, you know what, once in a while these judgments come, you know, what is called restatement of laws. Judgments called restatements, which restate all the previous laws. Those judgments are very useful for us because it can give us a
I
summary.
think that one judgment can be cited to
Yes.
face the entire
Yes.
gamut of the law.
Like Pranay Sethi in MACT, say something like that. Anyway,
CD is there.
that's okay. I'll need the city, of course. I'll try to do it today only.
Yeah.
Right.
Diploma.
Okay.
61.
It was 2 p.m. Yeah. Let's go fast. No,
I will not take much time.
no, you're being apprehensive.
No, because so many persons are there in the line.
Yes, yes.
In anticipatory bail matter, so much time has been taken. My lord, your lordship will kindly see that paragraph. In my petition, my lord, yesterday I have already shown
Yes.
that he is an internet cafe owner. Paragraph page 28.
They have a different take that he is also part of that. Anyway, that is what you had submitted, no, sir? Mr. Kyle?
Page 20.
Yes. That is what you had submitted, that he was also part of that.
Yes, sir.
Their contention is that he was just a cafe owner.
Cafe
Yes.
owner.
Para,
And my lord, para 10, 11, 12, your lordship will kindly see, this 25% they went to the petitioner's cafe at 7:30 AM and they picked up all his materials and himself. Now, in the complaint petition, they are saying that he was summoned. In complaint petition, your lordship will kindly see pen, 10, 11, I have given the.
yeah, page 10,
What is
para
it?
12.
Para 10, 11 and 12. I've narrated the story, my lord, how they have taken the petitioner and brought him to the GST office. And they could trace them only because from their mobile number, my lord. Now, complaint petition, your lordship will kindly see page 15. 15, your lordship will kindly see paragraph 5. Paragraph 5, it says, my lord, that summons under section so and so has been issued. Your lordship will kindly see when someone was issued, whether they have complied with the provisions of Order 5 of the CPC. Summons we have not received, my lord. We have been picked up from the cafe, my lord. Then, my lord, your lordship will kindly see paragraph 7. Statement of Samir Malik. He says that he is the owner of all this farm. I am not the owner. He goes for registration or GST payment.
Bahadur, he's Bahadur Islam, right?
I am Bahadur Islam, my lord. Paragraph 7, if your lordship has gone. Paragraph 9, my lord, data in respect of paragraph 9.
Yes. Okay.
My lord, paragraph 9, your lordship will kindly say.
Yes.
That the scrutiny of data derived from GST portal in respect of NA Enterprise and e-waste. I am not the owner of this. Samir has himself accepted in paragraph 5 that he is the owner of all this. I am not the owner. So therefore, my lord, on this itself, and now they are saying that paragraph 10, they have made an assessment some 8 crore 59 lakhs rupees. Not a single supply from my farm, not a single amount came to my farm. Not a single, your lordship, not a single paisa came to the petitioner's farm, nor a single supply has been made. So in that view of the matter, I say, my lord, this is completely his arrest itself. My lord, no information was given to him. His arrest itself is in violation of 47 and 48. And your lordship will kindly see that decision which I have shown when they have made the assessment. Have they made that decision? That decision.
Varun Goel.
Varun Goel.
Our High Court.
Yes. No.
Long judgment.
The paragraph 8, 9, 10, your lordship will kindly see, 12. And ultimately the bail was given on the ground that grounds of arrest was not given to him. As per circular, paragraph 9, your lordship will, there is a circular. I have a copy, but I'm not giving it to your lordship. Yes, I can. Yes.
Okay.
Well, that circular says issued by the Government of India, Ministry of Finance, Department of Revenue, Central Board, that is wherein it is clarified that in cases where there is no actual supply of goods or services in respect of transaction, your lordship will kindly see the records. What has been supplied by the petitioner and what money has been received by him. Whether any single paisa has been received by him in his accounts. So, and when have they made the assessment? That 8 crore some amount has been received. They must make the assessment also, my lord. So therefore, paragraph 9, 10 also said, my lord, no assessment carried out. This is submitted in present that no assessment carried out by the competent authority. There are cases that they have called him at 5 o'clock on 13. I have advised my client, my lord, you file an FIR against those officials. They have brought him from the cafe, and then thereafter, my lord, they are saying that they have summoned him. So this is a case, my lord, where, my lord, section 47, 48 has been violated. No information has been given to the petitioner at any period of time regarding ground of arrest and who has authorized them.
Authorization is also required, my lord. The judgment, your lordship will kindly see paragraph. 56. Paragraph 56 of the the lordship knows about it, that paragraph regarding violation of 4748.
GST.
Yes, not GST, my lord, in regard to information required to be given at the time of arrest.
Oh, that's okay. GST, I'm learning,
Yeah.
I'm not so familiar.
GST, my lord, your lordship can see paragraph that section 132.
Yes,
132, your lordship will kindly see.
Paragraph 132 of?
No, section 132.
Okay. Econ GST. CGST. CGST. You wanted to show me one paragraph of our High Court judgment?
Yes, paragraph, High Court judgment, paragraph 910, your lord will.
Oh, that's I have marked.
910, then reason to believe as per section 69 that is required of the CGST. The 69 is, my lord, 69 says 69 power to arrest. So before that, you must have the reason to arrest. You have called those persons according to you.
Section 69.
69, power to, where the commissioner has reason to believe that a person has committed any offense specified in so and so of the section 32, 132, which is punishable under clause 1 or 2 or so and so, or subsection 2 of the said section, he may by order authorize any person of central text to arrest such person. Where a person is arrested under subsection 1 for an offense specified in so and so, the offense authorized to arrest the person shall inform such person of the grounds of arrest and produce him before a magistrate. This is the requirement of section 47 and 48 of the BNSS. That judgment, your lordship will kindly see, which I have given paragraph 56. The ground of arrest is to be provided to them. And in the case which I have given of the Guwahati High Court, this after noting the notifications of 2022, where supply and one has to see that one has given supply of the items and received some amount. In the absence of that, my lord, where is the question of default on the part of the petitioner? Who is a cafe owner? Let them produce any records to show that the grounds of arrest has been given to me, and your lordship will kindly see no paragraph 21 of the Guwahati High Court judgment in Varun Goel.
Yes.
Ultimately, my lord, the non-compliance of section 41 and 41A corresponding to of the VNS Act has been found. So reasons to believe not produced. Paragraph 21 and 23. Yes. Has your lordship got it, man? Yes, I can read it, my lord. But I am also away, my lord. Before delving into the merits of the matter, 21, I am reading it.
Yes.
Matter or rendering any conclusive finding thereon, it is pertinent to note that certain submissions have been made recorded on behalf of the petitioner touching upon the merits of the present petition. However, at this stage, I consider it appropriate to restrict the scope of the present order solely on the prayer of bail as made by the petitioner. It is also noted that the learned counsel for the state respondents has sought time to file a detailed written objections on the merits. Then paragraph 23, my lord. Paragraph 22, I can read, my lord, for the purpose of 41, 42, 41A. It is admitted fact that the respondent note 2 accused authorization of the arrest of the petitioner to the respondent note 3. On perusal of the grounds of arrest, it appears that certain reasons have been assigned for effecting the arrest, but it cannot be denied that there was no proper compliance of section 41 and 41A of CRPC corresponding to section 35(3) of the BNS, which are mandatorily required to be followed. From the view expressed by the Honorable Supreme Court in Radhika Agarwal, it is evident that though the GST is a special enactment, but the same cannot be considered as a complete code in itself as regards to the provisions of search, seizure, and arrest. And as stated above, the provisions of Code of Criminal Procedure would be applicable unless it is expressly or impliedly barred by the provisions of the said Act.
But here in the instant case, it is seen that there is no compliance of section 41A of the CRPC corresponding to section so and so of the BNSS, which is mandatorily required to be followed as per guidelines of the Honorable Supreme Court. Now, the reasons to be believed, my lord. It is also noted, also admitted position that though the grounds of arrest were communicated to the president, here we are saying grounds of arrest was not given to me, present petitioner, but there is no communications of reasons to believe which ought to have been recorded before issuing authorization letter of arrest. As held by the Supreme Court, the requirement of furnishing the reasons to believe to the arrestee is not a mere formality, but a substantive safeguard enabling the persons concerned to challenge the legality of the arrest in accordance with law. Here, but here in the instant case, though it is stated that the reasons to believe were duly recorded by the competent authority prior to issuance of the authorization to the arrest, but there is nothing on record to show that the same were communicated. Nothing has been communicated to me. Petitioner is completely dark. He doesn't know why he has been picked up. Not only picked up, my lord, his entire, my lord, machineries have been also seized by them without giving a seizure list. Very high-handed action on the part of the authorities, my lord. Then, my lord, interim bill granted at paragraph 25. Paragraph 25, my lord, your lordship will find. In view of the entire discussion made herein above and also considering the view expressed by the Honorable Apex Court in the case laws, the referred to herein above, as well as taking into account the period of detention already undergone by the accused petitioner, and further considering the law in Arnab Manoharan Goswami case as relied upon the petitioner, this court is of the considered opinion that further custodial interrogation of the petitioner does not appear to be necessary for the purpose of investigation at this stage. So what I pray, my lord, your lordship will kindly look into whether when they have given me the information with reason to believe that he is involved in the GST. And on the face of the complaint itself, I have shown that the two farms which they are talking of, my lord, it belongs to Mr. Samir. I am not Mr. Sarim. And my lord, I am a owner of a farm that is at page 28, and also I am in the business of solar panel. So that is no way connected with the GST. Not a single paisa received in his petitioner's account, and the petitioner has not made any supply. So in the absence, as per the notification of the 22, my lord, as has been recorded at paragraph 9 of this judgment, my lord, Varun Kumar's judgment. I'm not placing any other judgment. So many judgments are there. So because so, my lord, 9, my lord, it quotes, my lord, about a notification.
Yes.
That notification I have.
You have given me.
Yes. So notification says, my lord, when
This is issued by the CB, Central
Yes,
Board of
yes, yes.
Excise.
And that is paragraph 9 of this. So he has not made any supply. He has not received a single paisa, and his grounds of arrest has not been communicated to him. Last, my lord, your lordship will kindly see section 132. 132, punishment for certain offence. 132, whoever commits any offence following the following offences, namely supplier any goods. I am not a supplier of any goods or services or both without issuance of invoice. We have not done anything, my lord. Issue any invoice or bill. I have not. My email was my lord, used. That is there. But all the supply, etc., has been made in the name of Mr. Samir. He himself accepted. And avails input credit. I have not made any. Then this is completely missing. So collects any amount. Nothing is there. Well, if they show from the record that in my account some money has come, the entire things will be different, madam. Collects any amount and so evades tax fraudulently. Nothing. I am not liable to pay any tax. So all these, my lord, points, my lord, which I have shown at section 132, nothing is applicable to the petition. So in that view of the matter, I surmise only submission before the court is that this petitioner's prayer for release from custody is on 3 points. One is that no communication as regard the reasons for arrest has been made. Second, there is no violation of section 132, and the petitioner on the face of the complaint that the petitioner is not the owner of the farm from where any supply or GST account has come.
Okay.
So therefore, my lord, I have to humbly submit, my lord, he is a small-time businessman. He has been arrested on 13 in a very high-handed manner. And that also, my lord, and how the summons has been issued, your lordship will kindly look into that. Section 70 of the GST Act shows power to summon persons to give evidence and produce documents. The proper officer under this act shall have power to summons. How they have issued the summons to me? They said, my lord, that on their summons I have come before the court, before the GST office. Entirely wrong, my lord. Access to business premises, nothing, no information has been given. In a very high-handed manner, these officials, they have went there, picked up this person along with his nephew, and just after, before production, before 2 hours of the production before the magistrate, some copy has been given to the petitioner's nephew, my lord, who was also picked up by the officials on 13/11/22. I humbly submit, my lord, your lordship will kindly look into the record.
He was, I'm just refreshing, he was arrested on
14. 13 he was picked up.
I've written down.
13 he was picked up at 7:30.
And
Now
formally
they-
arrested on 14/11.
No, but they say, my lord, he was summoned on 13.
He was summoned.
On 13 and he was produced on 14. And before 2 hours, some information was given to another person who was picked up by them, who is supposed to be Muslim. There is no record to show that information regarding my reasons of arrest, etc. has been given to me. I don't know. 5 crores, 8 crores, they are saying in the complaint petition, not a single paisa in my account.
Anyway. Which is the trial court for these offences?
CGM.
CGM, special magistrate.
No, we normally file complaint before the CGM. That is allotted to different judicial magistrate.
Any magistrate.
Yes, sir. Let's see, my first submission, a lot of allegation has been leveled against the officers. Entirely, all the allegations are false and incorrect. Lordship, regarding a arrest memo and compliance of different provision of law, Lordship casually will reveal the arrest memo, authorization letter, everything has been provided to the petitioner. And 47, 48 will be complied with, and petitioner is admitted. Lordship, my learned senior friend has read out many things, but he has not read out page 19, paragraph 8.
Page 19 of?
Bail application. Paragraph 8.
Page 19, paragraph 8.
That in his statement, Bahadur Islam, the petitioner, has inter alia stated that. Let me please to note that this was before his at the time of arrest. This application was filed before the London Magistrate. Thereafter, Lordship, he was integrated in jail 2 times. Yesterday he was integrated. He has revealed many things.
That
Statement Sri Bahadur Islam has inter alia stated that he met Sri Samir Malik alias Imran in 2023. Samir Malik approached him as a client for GST registration of his firm. He accepted the job and ever since Sri Samir Malik has applied for multiple GST registration for various firms, indicating methods e-waste number so and so, for which he provided his official email ID number so and so.
Yes, I think.
Then B, he is proprietor of Messrs. Neha Traders, GST number so and so, which is a supplier of solar panel and related accessories, for which he never utilized any fake invoice to avail fake ITC, but he has procured fake invoices from Sri Samir Malik alias Imran for several of his clients. Then C, he has communicated by Samir Malik alias Imran that he can be provided fake invoice for availing fake ITC ever needed by him independently. He received an inquiry from company secretary Sri Mirganka Rajkhua number so and so that one of his client is willing to purchase fake invoice. He acted as a broker between Mirganka Rajkhua and Sri Imran, for which I received 0.5% of the total invoice value of his commission. A total face value of 3.75 of the invoice were transferred by Sri Rajkua through UPI on his phone pay account number so and so, out of which he kept 0.5% of his total invoice value of his commission and passed the rest of the money to Sri Samir Malik alias Imran. He accepted that he has applied for registration of firms without actually ascertaining their existence or genuineness, and he further received payment of rupees 8,000 to 10,000 per company. He accepted that the benefit from the registration of non-existing company at the rate of rupees 10,000 per fake company. So this was the initial, he revealed all these things.
This
This
is their complaint, my lord.
Yes, this is not a complaint. This is the demand application before the magistrate. Lordship. Then Lordship may come to section 136. And Lordship, he was sent to judicial custody. As the department has no provision for keeping any accused. So we didn't ask for police custody. We asked for judicial custody, and he was interrogated twice, Lordship. Yesterday he was questioned with
In
the jail.
JC.
Yes, Lordship. And Lordship, he revealed many things. Lordship will be surprised that how they were doing all these things. Lordship, section 136 of GST Act. One three six. A relevancy of statement under certain circumstances. A statement made and signed by person on appearance in response to an summon issued under section 70 during the course of an inquiry or proceeding under this act shall be relevant for the purpose of providing any prosecution for any offense under this act. The truth of the fact which continues. Let's say then 1 and 2 is there. So Lordship may please to see the case diary where he himself subscribed to the question put by the authority, Lordship. And we kept, Lordship, all the videography is there, Lordship. So, and Lordship, section 35, 3 notice was issued to him. That was in Barun Gaval's case. This honorable court says that section 35 notice is necessary. That was also complied with. And section 47, 48 all have been complied with. And Lordship, 69 is also complied with. Declaration of arrest has been given to the petitioner also. He received that and he's put his signature. And all the witnesses are there, Lordship. Making allegation against the authority, Lordship, is a common thing, Lordship. Lordship, please to see the FIR, the case diary. Lordship, yesterday he was questioned in jail. He revealed all the things, Lordship. Lordship, just for instance, I'm giving one. Please state who sent these 89 pages invoice, so and so. Let he implies that I do not know. Then question number 7. How much money you get as consideration? I receive good sum of account according to the invoice value.
Fake invoices.
Yes, Lordship. And Lordship, another statement was made that assessment is necessary. Lordship, in Supreme Court, in case of Radhika Agarwal, in paragraph 62 onward, Supreme Court says that for making arrest, assessment is not required. Only satisfaction of the arresting authority is sufficient. Lordship, all these documents are here. We have plate mark for perusal of your Lordship.
Okay.
Lordship, here the investigation at the end stage is reveal anything, and furthermore investigation is necessary.
Any reply?
My Lordship, regarding cooperation, Lordship may please to see how he is cooperating with the authority. And he was questioned in jail, Lordship, before the police.
He was
officer.
cooperating. He's cooperating.
No, Lordship.
He's not cooperating.
No, Lordship, may please to see. I do not know.
I will see properly.
It was,
I'm constrained.
I forgot to reveal all these things.
Lord, if the case diary reveals that they have given information to the petitioner as per requirement of law regarding the ground of arrest with reason to believe, my lord, I will have a weak case. This is one.
So, fair enough.
Second enough, my lord, your lordship will kindly see the notification dated 22. If they find any record that the petitioner firm has supplied any materials or has received any amount, I will have a weak case. I concede, my lord. Your lordship will kindly see into the records.
Now, the notification part, your lordship will kindly see that notification, it is 6 July 22. 6 July 22. It says, my lord, there has to be a supply of goods or services or both therefore. Well, how they come into consideration the amount of rupees 8 crores or something. Well, 8 crores is a very big amount. Malad, when a petitioner's amount, because malad, if it is 5 crores, malad, then it is a bailable offense. If it is more than 5 crores, yes, it is
That's
the
a law.
provision of law is that.
Because the volumes are very big.
No, if the volume is big, malad, more than 5 crores, it is a non-bailable offense under the GST. I'll point out that particular.
It's okay. I'll check.
So therefore, my lord, if the record reveals that my farm, the petitioner's farm has received any amount, has supplied any goods, my lord, then it is, I'll have a very weak case, my lord, your lordship will decide. Otherwise, my lord, all the investigation, he is cooperating, all the documentary investigation, this is a documentary case only. So therefore, my lord, if all these parameters are not false true, my lord, the lordship will allow him to go. Otherwise, he will cooperate, my lord, and he will come daily, my lord, if necessary. But your lordship will kindly see that page 28 is his farm. It is his farm. The other farm which he has given, there is nothing, no materials against that farm. That farm is relating to some solar panel. That's a separate business he does. Solar, whenever he gets some idea. Otherwise, if the material shows that some money has been received in his farm, he has supplied any goods, then the thing falls through. That provision of notification, your lordship will kindly note. Look into 6 July 22, that notification. It is clarified, my lord. I'll just read one more page. Since there is only been, and it is a clarification, only been issuance of tax invoice by the registered person A to registered person B without underlying supply of goods or services or both. Therefore, such an inquiry activity does not satisfy the criteria of supply as defined under section 7 of the CGST Act. As there is no supply by A to B in respect of such tax invoice in terms of provisions of section 7 of the CGST, no tax liability arises. So therefore, my lord, your lordship will kindly look into the record whether this petitioner has made any supply or he has received any amount in his account. How they have said, my lord, that 8 crores, my lord, and he is connected with this petitioner. Not a single, whether they have checked into his accounts. How much money he has got. And my lord, provision of law is that, my lord, if it is 5 crores, then below, my lord, it is an available offense. And if it is more than 8 crores, more than 5 crores, it is a non-bailable. So under these circumstances, my lord, I say your lordship can look into whether provisions of, whether the grounds of arrest has been provided to the petitioner at any period of time. With reason to believe that he has committed some offense. So there must be something they must have assessed by inquiry that he has committed this offense, which is a voluminous of 8 crores. It's a huge amount of money, 8 crores, not a single amount in his account. The lordship will kindly look into the account.
I have not the relevant part, lordship authorization letter, section 47, 48. When 53 notice.
Yeah, when they have served the notice
And
with
also
grounds of arrest.
Interestingly, in entire petition, in the bail petition, only allegation that notice under section 35 has not been served. Regarding 47 and non-compliance of, nothing has been stated.
That's a matter of law, my lord.
What's my pleased to see the case diary, everything is, let's say I'm submitting the judgment, paragraph 52 onward, this is on the GST matter. And this paragraph 53 says that for making arrest, assessment is not necessary, primarily satisfaction of the arresting authority is required.
Satisfaction, even my lord, this is no amount has come to the petitioner's account.
Lordship, only coming the money for account is not sufficient. His role is to be seen, Lordship.
Yes,
That we-
he has not made any supply also.
His statement may, Lordship, clarify everything.
I'll see.
Lordship.
My lord, your lordship will kindly consider that 5 crores is, my lord, bailable before, then how this petitioner is involved in 8 crore?
Can you just assist me on that point before I close?
Lordship.
That this 5 crore
Yeah,
thing.
yes,
no?
Lordship, that is authorization letter is there. No,
It's
the-
above 5 crores.
Yes, Lordship,
crore.
section one,
To reserve.
132.
Right? Reserve. Heard arguments, so reserve. Case that will be retained.
Lordship, 132.
Punishment.
Lordship, it shall be punishable in case where amount tax evaded or amount of input tax credit wrongly availed or utilized or amount of the refund wrongly taken exceeds 500 lakhs rupees with imprisonment will term which may exceed to 5 years or with fine. Then if it is 5 crore and above, then it is not available, and below 10, Lordship, it is available. And maximum punishment is 5 years in case of it is exceed 5 years.
I'm reserving this, huh?
Yes, yes. Yes,
But it's a bail application, I realize. That
We have already. flag
hopefully
mark-
Monday. be done.
We have already
Right.
flag mark relevant for.
Well, I've got another matter, 40, item 40.
Mhm.
The statutory period is over, man. Today is 61 days.
Yes, it's time constant is. Anyway, so some matters are inherently complex. It will take more time naturally.
Yes, naturally.
CPST method because. Another judgment where the bail has been given in CGST method. under
Same,
the-
you submit it, yeah.
Yes,
One
yes,
is this.
same case.
But please write P, huh? Petitioner. And this. Be in the file.
40.
40.
Oh, thumbs up, I'll tell you. 2 minutes, please, 40 minutes, 40. I did 40.
My lord, I was taken into custody on 28, 9,
That will
25.
be paid, it's over.
Today is 61 days, my lord.
I mean, otherwise, we are on which matter? I mean, that's, we are on which matter otherwise?
25 over again.
Or 25. You're upgrading it in a way.
Yes.
Please.
61 days. Your lordship has given an objection on the day and fixed it today.
See.
They did not receive.
Hmm?
They did not receive.
We can take that investigation is not complete that way. We can we hold? So do you have any instruction regarding investigation, whether it is complete or not?
I have to take instruction.
Can you take?
Well, it is the second case where I have been implicated. Yesterday, already Honorable High Court has granted me bail money because the completion of 60 days.
Whether your prosecution has take instructions whether any penal provisions are added in the meantime? It was-
No, nothing has been 406, 406, 420 minutes.
Charge sheet,
No charge sheet, has been.
not yet charge sheet.
Not charge sheet.
Okay, I will
Only
take
316,
instruction
that is
whether
420.
Case filed or not lawful.
No, you file, take the
Yes,
instruction. Take the instruction. Today only you take the instruction. Can you? Take the instruction. Hold the instruction. Because statutory bail is different thing. You don't have to go into merits. We have to be sure that in the state, it has not come into the record. Filing is not anything. 25. Let us finish whatever we can quickly. 25. Supplement with, yes, bail get us a supplement. Both us. Both us. Scan record has been, has come.
No lordship, TCR not received.
TCR not available.
What is this? Educated. 25.
He said, I said.
Scan teacher has come, has come. Has come.
25, I said.
Not showing here in the cost lordship.
You are for the informant? Eighteen eight. Anyway, so trial is not started. Allegations are quite serious.
Not gone through the record.
Allegations are serious.
Yes, Lord.
Video viraling, all that stuff. And then using that to repeatedly commit the offense.
No.
What is your submission at this stage? Hmm?
I'm with the submission.
Uh, It has just been charge sheeted. Trial is not started, right? So I think you'll have to wait for some time. Then.
It has to be examined.
You'll have to wait for some time.
Lordship,
Hmm.
it may be taken on Tuesday, Lordship, today, heads up kindly.
Nothing will change. Don't fix it on Tuesday and have some problems on Tuesday. It can be any other date, Wednesday, Thursday. Okay, the scan TCR has been received. The case has been charged sheeted, but it appears that trial has not yet started. The learned counsels seeks praise for listing the matter on next week for disposal. Accordingly, fix on 4th. 4th or 3rd? 3rd? 4th. 4th.
Another prayer, Lordship.
Yes.
Item 56, kindly pass over the order, pass of order. 56. Something.
56, CD is silver.
It is received. Any interim orders there?
No.
Interim orders there? Okay. Retained CD 56. List same day. 4th. 56. 56 is an NDPS matter, I think. So I think you retain the CD. We can fix this on 3rd. This. Gonaji, 3rd. I got to 4th, to 3rd. Yes.
Okay.
Lordship, though this is 483, Lordship. Lordship, he is not behind the judicial custody, he is on interim bail, Lordship. So CD was called for several times. Now, they have.
No, you're for the,
Charge sheet.
you are paying for this. It's an observation that, what is the FIR? No allegation, no ingredient of 10, 12 POXO, there's an observation. Why?
Lordship, merely, FIR page 18, Lordship.
Oh, yes. This is just assault and all this
Yes,
kind of.
Lordship, there was just a fight.
aggression.
Lordship.
Right, serious, come.
They did not receive, Lordship, already charge sheet submitted, sir.
Charge, I'll dispose it of.
He is an interim bail.
Just a
Maybe
minute. Let me see, cross check whether there's any element of crime against women in which sort of.
No.
Honest was I was struck with. Okay, I think apparently there's no allegation under POXO. That's true. There's a rightly given interim. I'll dispose it of, allowing it. I'll allow it.
Lordship, he has appeared before the
Yes.
trial court, submitted bail bond also.
Yes.
So bail may be made.
Yes. It's our order, family law, 25(9) order. First 2 paragraphs again. Stop. The accused was granted interim bail on 25/9/2025 with the observation that the acquisitions do not per se constitute any offense under 10-12 of the POCSO Act. Full stop. Maybe mention herein that in the FIR it is at least about some. One, 2 minutes.
Miller 483, the NS Miller. He was arrested Miller on 4th of May. Today Miller 233 days.
Scan copy was called for, but not.
Is it commercial quantity?
My lord. Commercial quantity and he is Miller 233 days, 103 days is the strategic period Miller. Now, Tarsi Samir, my lawyer friend informed us Miller for long back.
I see.
And it was called for, nothing has come. So not more than a period, so the trial has not started. Not letting go Miller and the trial will face Miller rising. Otherwise, Miller, how long he will be in custody?
37 is there, so
No,
37 determination has to be made. Otherwise, in a normal case, certainly.
Offense is Miller, otherwise I said offense is serious.
No, I mean, the specific statutory provision.
I cannot deny.
So let us see the scan copy. Yes,
But they are-
get the scan copy. We'll see.
But they are not bringing it. Miller. This is the third day Miller today.
So that is a legitimate grievance that it has been pending for scan copy that we should address. The accused is in custody since 5/5/25 in connection with Matia PS case number 35 of 25 under 22C of NDPS Act. As the case has been charge sheeted, scan copy was called for, but not yet received. Stop. Issue fresh requisition for the scan copy of PS number will do, or this special this NDPS
They can solve, we have not received, but PS case number may, yes.
from the court of the learned special judge Gwalpara. Matias Gwalpara. Gwalpara.
As a last chance Miller, otherwise it is the third day tomorrow. So.
This the scan record may be procured expeditiously. So since we need, no, that's why we'll need.
May I request one thing, Miller? Any registry may be.
Yes, it will be through the registry. The registry is requested to procure the scan copy through the registry, right? It will be
Yes,
through
sir.
the registry, scan copy expeditiously.
Must. Date given Miller.
Date list on, you suggested it. You can suggest it.
Will on 8.
Next to next week. Don't take next week.
4th of December?
My lord.
Or
No,
not?
no, 4th.
Eight-
Next week, I
8th
mean,
of
no.
December.
Hmm?
8th of December.
8, will it come? If it good, if it comes,
Come, Miller.
10 or, okay,
10.
as you wish. Yeah, I'm randomly saying. 10.
Must.
So what should we do? That matters here. Yes,
Well, item 33 is in jail, my lord. Scan copy was.
no, I'm not rising actually, but
Before.
I'll take a 1-2 minute break.
Oh,
No,
my.
can't sit at a stretch. Have some problem. 15 minutes. Full to? No.
59.
Oh, yes, yes. Yes.
Application is your lordship, the mother of the accused petitioner has lost an FIR on 9/11/2025.
Mother has lost.
Yes,
FIR.
she is 99 years old, and most important thing is that she is a dementia patient, your lordship. Thereafter, she went to the dispute police station, alleging so many that the accused petitioner has been assaulted her mother, the victim, the mother of the accused petitioner. And accordingly, he has been sent to the judicial custody, and today it is 19 days, your lordship. CD has been received, your lordship. Yesterday also, the CD has been paid by the.
Yeah, this, I was just thinking that now this new act is there.
Yes, sir.
Maintenance and welfare of senior citizens. and
Yes,
parents.
I understand that, but
No, that section has also been given.
yes. The CD is, no?
Lordship, here, one IO notice there, Lordship.
The victim, who is also the mother of accused, now intends to peacefully reconcile the matter with her son, who is the accused in this case, owing to her old age and her diagnosis of dementia as per stated by the complainant. Otherwise, statement of victim lordship, she lordship implicated.
Mhm.
Later on, lordship,
Mother, she has given a,
yes.
you know, that she will tolerate everything and still excuse him anyway. If there's a, can I see?
The allegation is concerned in the FIR itself, Your Lordship.
Anyway, it's not be necessary to detain him, provided he does not, cause torture upon her again, suppose it's true. If they live properly, there's no need to detain him. But that's true, but we don't know their family situation. Case diary has come.
Yes, sir.
She is a dementia patient.
Yeah, no, don't bother. We shouldn't. Many people have dementia and all this. It can be managed nowadays. There are many medical advances.
Yes.
Not sometimes it is difficult, but it's not a stigma. It should not be seen as a stigma.
Yes, yes.
He's tried to strangulate him, and he also has a drinking problem. All these things are there.
If that is the correct, Your
A
Lordship.
court order took custody of the victim. Guardian of the victim, Adhikar Chaudhary.
So medical reports.
Okay, no, it's okay. I'll allow the bail, but just saying this. This is a relief that now they are willing to. So I'll impose a condition like that. I don't know whether it will work or not. You can convey to him. You can convey to him. I've always believed that advocates, conveying or advice, it really works. It works. Heard, invoking 483 BNSS. Petitioner Pranav Chaudhary is seeking regular bill in connection with dispute PS case number 908 of 25 under section so and so. The FIR dated 9/11/25 has been lodged by his own mother, stated to be aged 99 years, with the allegation that he has been inflicting cruelty and torture upon her, and even assault, demanding money for drinks, etc. The accused was arrested on 10/11/2025. In the meantime, case diary has been received. Statement of the victim has been recorded. The IO has made an endorsement that there's reconciliation between the accused and the victim, and intending to peacefully live together. In view of the same, I am inclined to allow the bail subject to suitable conditions. Accordingly, allowed to go on 20,000 with 1 surety. Satisfaction of the arresting authority. This 4 PS, right?
Yes.
This Karmuk Metro, subject to the following condition. Number 1, he shall not inflict any pain or harassment or cruelty upon his aged mother, who is also not keeping well. It's number 2. He shall I'm just writing. He shall conduct respectfully and with love towards his mother. Number 3, he shall cooperate with the process of law, and especially with the provisions of with the process of law.
Much obliged. Deeply.
Violation will lead to cancellation of bail. Just right. No, I'm just writing that standard, that violation might lead to cancellation of the bail. No, you convey to him.
Yes.
Take care how long she'll live. Just
28.
20?
8.
It's for the scan copy of the PCR. Lordship. Lordship, it is the second date. Whether it is available or not.
Never mind, in the second wave, another, when was it? It was rejected by this court? No, High Court session, then it's not a second bill in a sense. Usually understand in the same court, subsequent bill petition. We can have a fresh look.
Has been called for the last 2 dates, but it has not.
It has not come. Charge sheeted case, what is the section for commercial?
Commercial is there.
Commercial.
Lordship, my involvement is not there. Lordship, I am a
Right.
21-year-old.
Some co-accused was granted bail in this case.
No, Lordship.
Yeah, some Sai logistics appear familiar to me. Maybe some other case I have handled. Anyway, but diary would be necessary since it is commercial quantity.
On the second last date, Lordship took this matter.
Must have,
So might have been.
no, must have heard something.
Lordship, I have a 21-year employee, a godown keeper employed under a logistic company. So my involvement, Lordship, I have just delivered the things.
It was
That-
found to be having drugs.
Seal cartoon, that was seal cartoon.
So anyway, we need to see, unfortunately, he has been arrested, so we have to see, right? Get the record, huh? Please get the record. Investigation?
Lordship,
No,
There's
it
no
won't be
secret.
record if it is investigation.
In the grounds,
Are you sure it
already
is charge
charge
sheet?
sheeted, Lordship.
charge sheeted,
Charge
Lordship.
sheeted, Lordship.
Trial is
The
to start.
charge sheet was received by the learned session court, but due to presence of FSL report in the charge sheet, it has been returned back. Lordship, charge
The
sheet,
charge sheet number is there.
Sure.
3 grounds undertaken by the IO in the FIR. One is, Lordship, that needed for interrogation is to unearth deeper links and criminal conspiracy under section 29.
We'll go into it, not detain ourselves at this moment. Issue fresh reminder for the scan TCR of Gorsuk PS case number 235 of 2025. No, not possible, not because 37 is there. Interim can be given, but again, you have to pass the test of 37, right? 22C NDPS. DPS and full stop. The case is stated to have been charge sheeted by its CS number, that will help. Give
CS number 249/25
25.
dated 25/10/25.
The scan TCR may be procured expeditiously. Leave the matter on, you can suggest a date. Suggest a date.
On
8, 9, 10.
14? 14th of
14,
December.
earlier, I don't, 14, okay. 14,
14.
just check. It's Sunday. 4 days Sunday.
If 10, it can be a Lordship.
No, 12, you can take it on 12. 13 is also Saturday. No, 12. deeply.
29.
We almost done actually. Last matter, then we can go for mention.
Pleasure, Lordship. I will not make very long submission.
No,
Lordship.
so-
Know the law on this point. Few cartons of cough syrup were found in the yard of my house level. At that time, I was not arrested by the police. Subsequently, my lord, charge sheet was submitted wherein I was shown as an absconder. Summons were issued with the trial court. I appeared on receipt of the summons, prayed for bail. Obviously, my lord, my bail was not granted and I was taken into custody. Now, I've been in custody since 23/5/2025, so that will be 191 days as on today. The Caesar witnesses have been examined.
23/5?
23/5/2025. Caesar witnesses have been examined. Both of them came and said that they had signed on some papers which the police had shown to them. PW1 was not declared as hostile, PW2 was declared as hostile. But as of now, the two Caesar witnesses who have been examined, they have not even proved the factum of the Caesar. But that is anyway, my lord, subject to the outcome of the trial. Now, what my humble submission before your lordship is, your lordship will examine the fact when there is no physical possession, physical recovery from me, just because contraband was found in the yard of my house, where I am not the only resident. Whether conscious presumption can be presumption of conscious possession can be drawn up, because conscious, if there is physical possession, the presumption under 54 comes. Then I'll have to rebut the presumption and show that maybe I did not have conscious possession. So that element would come in.
It's in a house occupied by several persons. It is found in the compound.
Compound, not-
Conscious position. It is a challenging, it will be a challenging thing to be proved by the prosecution. It is challenging, not easy, because multiple persons are staying.
My respective concern before this honorable court is that when the contraband is admittedly found in the courtyard, front yard of the house where there are multiple residents, nothing additional exists to show that this was, I had conscious possession of the contraband, my lord. Whether the rigors of section 37 in the fact of such material, even if you go by the prosecution's case, the witnesses have not implicated, that's a different issue. But assuming whatever the prosecution says is correct on facts, my lord, whether the rigors of 37 can be invoked in this case or not.
Should
That is my
I-
case, my lord.
Okay, that is. So shall we complete it today? Another thing that always bothers me, we don't have time. Actually, suppose after framing of charge, a court, suppose a court handling, adjudicating an NDPS bail in commercial quantity, and in what ways it can say that test of 37 is passed? Evidence, witnesses, can it be? Because charge,
Yes, because my lord, charge is at the level of, at the stage of charge, the court will only go by prima facie satisfaction. If there is a prima facie case against the accused person, if the court can form a presumption that the charges are not groundless, then the court will go ahead and frame the charge. But while deciding a bail prayer, the court will examine at least as far as the first ingredient goes, whether there are reasonable grounds for believing that he is not guilty of the offense. That your lordship will examine. Now, for that, if the evidence has been recorded, your lordship can always look at the evidence. But aside from the evidence also, independent of the finding of the trial court vis-a-vis charge, my lord, this honorable court can always examine the material or the allegations for the petitioner, whether those are sufficient to fulfill the ingredients of section 37, my lord. So here, based on the accusation itself, my lord, in my respectful submission, that standard is not met, my lord. Because in that case, if finding something in the courtyard would make me liable, it would also make all the other residents of the house liable. They have not, why should I be singled out?
That's why I said it's a challenging thing for prosecution. And this my point which I was raising. Suppose after framing of charge, this the court says on a determination under 37 that he is not guilty. Won't it prejudice the trial and the prosecution? In a way. Now, this is the question. Just take a moment. We don't have time. But this thing, there was in the context of UAPA, there was a division bench judgment because UAPA matters have to be taken up by division bench from NIA. There was a case called Brajo Bidhu Singh. You must be aware of this thing. Brajo Bidhu Singh, in which the division bench said that in UAPA, if prima facie materials are true, you cannot give bail. So therefore, the court said that since charge is framed on prima facie materials, therefore after framing of charge, bail will not be maintainable. It held that view. It was referred to a full bench. It was referred to a full bench of a High Court. I don't remember that full bench, which included Justice Bhuyan also. That it said that in the context of UAPA, where the language is different, that prima facie are true. Then they made actually reasoning that it will be slightly above prima facie and less than guilt. So in between that, you can still entertain a bail. That was said. But here in 37, as you know, in Watali, Jahur Ahmed Shah Watali, it has been said that the test of 37 is tougher than the test of 43B of UAPA. Now, not guilty, but in this case, what happens after framing of charge? I don't have an answer to the question.
Between 45D and my lord,
Yes.
37.
Yes.
Here is not guilty.
Yes.
There is
It's tougher. This is tougher.
This is tougher, my lord. But then if this, for it to be tougher, my lord, the prosecution's case, for the foundational case has to be made out by the prosecution, independent of the finding of the charge, in my respectful submission, my lord.
Yes. Anyway, it is a evolving law. So should we keep it for Monday?
Keep it as part of in that case, my lord.
Part of.
My lord.
Should I keep it as part of? Well, but we have not done. Is it necessary to keep it as part of? Okay.
Then my lord,
Okay.
keep it on.
Part of.
Part of.
So I think we should start the mentions.
Deeply.
And I'm sorry, so many matters got listed. If we work together, we can solve this problem actually. For the younger councils, I want to share one thing interesting, that in your times, this is coming, I'm telling you, many countries, whatever little I know, in many countries nowadays, they are having, the emphasis on written arguments and time limits for oral arguments, subject to, of course, wherever it is necessary. This cannot be standardized. Some matter you can, this is coming in our, in our system also gradually, because it's like a doctor, if I unduly take too much long, the matter may be complicated, the case may be complicated, the disease may be complicated, it may need a 1 hour consultation also, but there has to be, otherwise other patients are there, other litigants are there, we have to, or maybe some complicated matters we hive out and make a special bench, it deals with that only, So anyway,
My lord, before your lordship.
This is
started
coming.
The
Yes,
mentioning,
yes.
my lord, item number 31, my lord, I was waiting, my lord, for the day.
What is this? You have come from outstation also, I believe. Yes, yes.
My lord, whatever it is, my lord,
Item 13.
I understand my friend is going to.
Just a-
On behalf of the CBI.
Uh-huh.
My first date
Huh?
for appearance is item 30.
Acha, you're also there in this matter. Just a minute. 31 is what?
Last occasion. my
Dhan Singh.
reflected.
Okay. Dhan Singh, it is. Dhan Singh was a NDPS case.
Yes, my lord, yes.
It has been transferred to CBI
Acha, acha.
and they have made.
Oh, I remember. It has some record was not found. Yes, yes, yes.
Absolutely.
So today we are appearing, we are respondent number 3.
Mm.
We may be given liberty to file reply, your lordship.
Well, that you can file, but
My lord, in that event, if it otherwise suits the order of the court, if I may come back on 15th of December.
15.
In the because they'll have clear 2 weeks time, my lord, in that time, I guess they can.
it's not kept as part heard. No issues then.
It is
No
not
issues.
part.
No issues. 15th. Okay.
15th, it is not convenient for me. It may kindly be done.
I have no problem. You work it out.
This I will not. But I
No.
am not available on 15th of
Take it just around that 16, 17.
16, yes, 16 we can make.
So, no, I have no problem. You just work it out. I can give you 15, 16, 17, whatever you prefer.
11 or 10.
My lord, in that event, may I have the liberty to appear online?
Yeah, but that's always there.
Fine. My lord, then on 12th, my lord.
That is always there.
12th, but I won't be able to come here.
12
today.
is Saturday.
This is 2026, yes.
If you do not face any inconvenience doing it online, then it's okay, no problem.
My lord.
You can at least start.
12.
Well, my lord, can it be kept at 2? If
Mm.
otherwise it is not.
Is it okay for you?
For my-
No problem.
Okay, two.
This
He
week
says
I'm-
online is fixed at 2 only usually. No problem. 2.
Much obliged.
Two.
May I please, your lordship?
I beg. I learned friend pay to take, but get any.
Kindly fix it on Monday, lordship.
But take the instruction, no? Because it's.
Lordship. The item 38 lordships, CD was
Monday.
CD was called for lordship.
Just a minute, because he is also 40 Monday. Okay.
CD was called for lordships.
Hmm.
CD may not be available. Item 38. And service was also awaited lordships.
Item number?
So 38. So my lord, next week lordships.
List after a week, huh?
Service was awaited, that may be.
Dates I won't be able to give, huh? He will give
Service
you
was
that.
awaited, that may be my lord
Can
recorded.
you do that? Huh? Take more অসুবিধা আছে। more lightly চাইছো। And আমার মই দিব। আৰু দুই লাইন চাইছো। গতিকে do it fix নকৰিব। Yeah, please.
Item number 38, charge sheet submitted, lordship.
What matter it is?
Well, POCSO lordship.
So, you scan copy,
Yes.
scan TCR. Or you'll approach trial court, scan TCR, call for scan TCR comprising CD and charge sheet and other relevant documents. And prosecution will take instruction regarding service. Regarding service? Yes.
Next week lordship.
But no, after, no, not next week. Let it be after a week, date fixed by
Yes,
the
that's
registry. Some dates we should leave for the registry also because they fix proportionately. Otherwise, fixing is the easier thing, as you know.
After a week lordship.
You people are so intelligent, but it does not reach, does not reach.
May I please your lordship?
Yes.
Please your lordship. Lordship, with regard to item number 55 and 57, my lordship. My lordship, this matter it has been coming for but couldn't reach my lordship.
Mm.
Yesterday also it came, my lordship, day before also. 55, 57, my lordship, can I pray that this matter be taken on 2nd of December, my lordship?
Second, please, because I have some difficulty. It may be, if it's before another bench, no issues. But this bench, I have some difficulty.
This relates to special act, and my lordship, I've just seen the new out, it has been out for the Monday list. My lordship is given 7 years up or and down, not the special act for the next cruise, my lordship.
But don't, because I have difficulty in personal difficulty on second.
My
So except second, you can seek another date.
My lordship, can it be on then third, my lordship? Can
Third
it
is,
be?
third is.
Third.
May I please, your lordship?
55 and 7, my or less.
My lord, I beg to mention item number.
Just a minute, earlier matter to key delay date. Date টা দি দিয়ক, BA নহয়, date এটা দি দিয়ক। Date এটা দি দিয়ক, date এটা দি দিয়ক, 8/8.
My lordship, one suggestion, if my lordship can take it on one, my lord, first December, can it be? Because 55 and 57. my lord.
1st December, yeah, 1st December, okay,
Can it
normal.
be? Can it be, my lordship?
No, we fixed it, when did we fix it? Third.
On the, but my lordship, my lord, can it be on first, my lordship?
Okay, keep it, let's see what can be done.
We have it
First.
First December, my lordship.
My lord, I beg to mention item number 60 of supplementary list today, my lord. And I will inform the CD has come, my lord. So may I pray for Monday, my lord.
Okay.
And my lord, another thing I should, my lord, mention before this honorable court, similar, some accused persons, my lord, co-accused has been granted pre-arrest bail, my lord, by my lordship, Anjumni Kolita, my lord. So matter.
You want, can we be posted there also?
Up to your lordship,
No,
but
no.
I have just explained it, my lord, the true fact.
In that case, what should I say? Appropriate bench.
And the earlier
So
order
that's
was
not
there.
Actually, appropriate bench হবে না কিন্তু।
But registry said, my lord, there is no bar. They called me. Therefore,
There's no bar, I think.
there is no bar.
Oh,
Lordship, up to you.
fixed on Monday.
Monday.
Some connected matters are pending or disposed of.
Disposed of.
Disposed of.
Pre-arrest
I
bail.
see.
I am my regular bail, my lord.
What was Monday? Lots of matters on Monday.
92.
Hmm?
92.
Let it be on 5th. 5th.
My lord, I am in jail, my lord. Therefore, I prayed, my lord, before your lordship.
Otherwise, 3rd or
And-
4th.
And matter is rolling up, my lord, since last.
3rd. No, these are the legitimate things, you know. We have a right to have the matter heard, listed. Anyway, so,
Maybe lordship. Lordship, back to matter item 35, lordship.
yes.
Lordship, in this matter, lordship, there was called for. Lordship, that submitted, but medical report was also called for. Medical report.
Medical report also.
POXO matter,
NDPS matter, lordship.
NDPS matter,
Because
commercial.
Others is their lordship, his blood sugar patient, lordship, for high blood sugar.
I have to
lordship.
see the file.
Yes,
I
lordship.
sent the medical report and lordship, the mail, even
Fix-
examined.
Fix it on charge sheet,
Lordship,
fix it on 3rd.
Lordship,
Monday, lots of matters, you know. Lots of matters, please don't mind. No. As I said, no, we can fix it, but it's not reaching 3rd.
I'm deeply obliged. May I please, your lordship? Item number 34, lordship. Can this matter be kindly taken on a date fixed after 15 December, lordship?
Yeah, no problem. Which matter?
Item number 34, lordship.
34. But it's a bail application. He's in custody.
Yes, sir.
Won't it be late for you? 15, after 15 December. Won't it be late? Today is 28. No? I can fix it, but if it's not late for you, then I'll record your prayer. Can I record your prayer? The Learned Council submits that scanned due to some. Why don't you take it any earlier date?
The senior's son's marriage, lordship. That's why you would not, won't be available.
To you, Learned Council submits that due to some personal difficulties of the leading council, the matter may be fixed after 15 December. Allowing the prayer list on. When should I fix it? 17? 17. You can do it. You are capable. You are capable. You can do it. Study the file. Do it. There.
Obliged.
We are there to encourage you.
May I please, your lordship? My lord, item number, my lord, 33, my lord. May come on, my lord, 3rd of December, my lord.
Okay.
But one observation may be given. Perhaps, my lord, wrong, my lord, case record has come. In the meantime, my lord, registry should, my lord, ensure, my lord, right.
I don't know. I have to check.
One observation, my lord, may be given, my lord.
That I don't know.
That is the scan copy receipt.
It is wrong
That
record.
I have to check, you know, it will not be proper because they'll get confused
But
if
only
the
my-
right record has come.
my lord,
Are you
only-
sure?
Yes, my lord. Only my lord, that observation, my lord, registry.
The registry may kindly
Verify, ma'am.
verify as to whether the
Right, police
scan
record has come.
record received pertains to the correct police case.
May please, my lord.
That's a fact.
Correct TCR, my lord.
Correct police case, the same
My
TCR.
lord. Diploma.
The third, yes.
Item number 39, my lord, regular bail, my lord, on second, my lord.
No, second, please.
My lord, on 8, my lord.
Eight.
Not available.
8.
On 8.
City on the process of the city on the-
Okay. It will reminder for the case there.
8.
Lordship,
Obliged.
Lordship, item
Yes.
65 supply was in your Lordship list yesterday also.
Oh,
That relates to a bail order modification.
Oh,
A
oh.
similar order is there. Your Lordship.
What was the modification necessary? Give me the file just a minute. 1 minute.
65 to 65.
Modification with regard to paragraph B and D of the order dated 11/10/2018.
Okay, way back, huh? That learned judge is not available, I believe. That who had passed the order is not available, I think. Who had passed the order? Anna? Oh, you want change of bail condition?
Yes, Lordship.
Which is the bail condition?
Para A and para D.
I'm just,
Sorry, Lordship, para B and para D.
can you show me the order? Which one?
Yes, your Lordship, it's
Page-
at page 11 to 13. 11/10/2018. IA criminal 1044,
Yes.
pages 11 to 13. And the applicant's name is at serial number 7.
No, I'm just checking the judge. Who had passed the order? That learned judge is not available now.
He has retired,
He
Lordship.
is retired. Oh, it's this one.
Para B and para D, I'm seeking a modification of that also. That part of the order. And similar order were passed on in another similar.
Territorial jurisdiction.
Yes,
Huh? Territorial jurisdiction.
similarly situated.
Okay.
Co-petitioner was here on 19/9/25. This honorable court had passed the.
I've
order.
understood. We'll do it.
133 to 135 is that order. Lord.
We'll do it. Chamber will do it.
Much obliged.
Already.
Lordship, item number 58. Yesterday, the listed Lordship.
Yes.
But not released. Lordship, in this case, I have prepared my some submission, Lordship. And Lordship can dispose it on the chamber, Lordship.
So,
Just-
there are so many matters. Keep it on Wednesday or something. 3rd or 4th. 3rd.
It can be Lordship.
You can submit that.
Lordship, second Lordship.
Huh? No, 3rd. 3rd. Keep it on 3rd. 3rd. Case diary has been received, shall be retained. Item 58. 58.
Specific mention of 2 PM Lordship, because yesterday also listed.
The 3rd. Actually this endeavor will be made to take up the matter at 2 PM if possible.
Lord, item 14. It's a pardoned matter, my lord. So if it is convenient, maybe on Friday.
No,
my lord.
leave this week thereafter. It's a bail, not a bail.
No,
matter.
no, it's a criminal petition.
Take it after that.
Okay.
After that. No.
As per your lordship.
9 you can fix. No, 9.
My lord.
Or should I leave it to the registry?
No, my lord, 9 will be fine.
Because we don't know actually. Because this
9 will be fine, my lord.
blind guessing actually.
If your lordship
The way our,
listen
we are,
to the registry, then it is not to this time.
no, don't take that. You know, that has to be addressed. No, they are fixing. They are fixing. I've seen in division bench also many things they are fixing. Sometimes if it misses, then you can always mention. But these systems, because they fix harmoniously, you know, because this we are just guessing, fixing by dates. We do not know how much matters are there, right?
My lord, why I'm pressing?
Okay,
because-
9.
Because
This
it's a
is 9.
pardoned matter,
No,
my lord.
9. It's okay. But
Much
some
obliged.
matters we should leave to registry also.
Much obliged, my lord.
Item 19, may I pray that it be taken up on 11th, Lordship?
Okay, it's on 11.
Item 48, interim order is there, shall be continued.
Interim orders will be continued, don't worry, it's not reached, all interim matters will be closed.
Regarding,
I think
48 Lordship, I'm for the
48 or 49?
48 Lordship. They have just mentioned
Okay,
Lordship.
that's
48
14,
Lordship,
48.
Yes, Lordship, 48 Lordship, we have prayed for Lordship vacating the stay order.
Stay
Lordship.
order.
Stay order, Lordship.
Uh,
Now, Lordship.
And
things
it's
is
not
in-
reaching.
Not reaching, Lordship. May I pray, Lordship, since it's a matter, Lordship, NI case, Lordship, negotiable instrument related to negotiable instrument act, Lordship, instead of Lordship piecemeal type of submission, Lordship, let it be fixed for hearing, final hearing for
But
disposal.
we'll need him, you know, because
Yes, just let the call.
otherwise he'll be aggrieved that you know, behind, he'll blame you. Blame me also. Let him, if he agrees, I have no problem.
It's a final hearing for final hearing on the.
Okay, let us do one thing, paucity of time. Let us fix it on 8. On 8. Then on that day, you inform him, and you can it can be referred to hearing.
Finally.
It can be fixed for hearing. Interim order has to be continued, of course.
Because the last occasion they
Eight-
said they have to file objection
I-
that they have not.
This
filed.
on 8.
Your lordship,
Okay.
I beg to mention item number 37.
Mhm.
The CD was called for, but it has not been received. So if kindly give us short date of.
He will give you
first
that.
or
Issue
third of
requisition for
December.
the CD. Any interim order? No.
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 37.
And he'll give a date. He'll give a date.
37 Lordship CS5.
CS5. What kind of case?
NDPS 22C.
Then we'll need the record, scan copy.
Scan copies.
No, we'll scan copy we'll have to get, scan copy of CD and CS. Including FSL. Okay. So, huh?
Scan copy date.
Oh, scan go date, which date should I give a date? Idea given.
Next one. 8. 8 Lordship. 8/12.
Okay. This is ad hoc, we're doing it in an ad hoc, but we'll let you think about it, young lawyers, the future is yours, you know, you have to have a work system where you feel more comfortable, all these things, because people have a right for matters to be listed, to be heard, you know, it's your right. Nobody should feel apologetic about these things. It's our duty to hear you, list you, but whatever problem